I'm muted. All right. Welcome to the Appellate Division First Department. This session has now opened. As a first order of business, I'm going to call the calendar and I am going to confirm to you the time that I have otherwise allotted for your arguments. The first case is People versus Feliz. That's submitted. Adler versus DIJ Mortgage Capital. Appellant has 4 minutes. Respondent is submitted. Kyriakos versus Shuang Zheng. The appellant has 4 and 1 for rebuttal. The respondent has 4 minutes. City Club versus New York City Board of Standards and Appeal. The appellant Extel has 8 and 2. The appellant New York City Board of Standards and Appeals has 8 and 2, and the respondent City Club has been allotted 8 minutes.
Excuse me, Your Honor, if I may, is that so? In other words, my adversaries get 20 minutes and I get 8. That's correct?
That is correct, Mr. Beer. I will assure you, though, that if we have questions and it exceeds 8 minutes, we will continue on with the argument.
All right, thank you very much.
All right, and we have your briefs and the record on appeal.
Thank you. Low bear, actually.
Low Beer.
Yeah.
Thank you.
Your Honor, sorry to interrupt, Your Honor. This is Eric Lee for New York City Board of Standard of Appeals of the same appeal. Does the court have a preference on which co-appellant should go first?
No.
And if not, okay. If not, then the city will go first on that appeal. Thank you.
If that's agreed, that's fine with me. People of the State of New York versus Merkin. Appellant Sandalwood has 8 and 2. Appellant Fabricant has 5. Respondent Dawson has 8.
Your Honor, this is Arthur Ralph says for Appellant Fabricant. May I ask that my time be divided 4 and 1?
Yes.
Thank you, Your Honor.
EPK Kid Smart versus Lorette.
Good afternoon, Your Honor. This is Ruth Rawls on behalf of the appellant. If it may please the court, I would request permission for Hilda Piloto to be admitted pro hoc vice to argue on behalf of the appellant.
Permission is granted.
Thank you, Your Honor.
All right, Ms. Piloto, you have 4 minutes. The respondent has 4 minutes as well. People versus Stacy Jackson. The appellant has 5 and 1. The respondent has 5. Well, excuse me. Bonet versus Rose Associates. The appellant has 5 and 2. Each of the respondents has 4 minutes. Ziegelstein versus Roth Law Firm. The appellant has 5 and 2. The respondent has 5. 27 West 72nd Street versus Tersey, along with 3120 East 28th Street versus Tersey. They'll be argued together. Appellant has 8 and 2, and respondent has 8. People versus Jose Crespo, that's submitted. Duragolamo versus 160 Madison. The appellant has 5 and 3, and each of the respondents has 3. Hendricks versus Wayne Center, that's submitted. Drimmer versus Zionist Organization, that's submitted. And Romero versus 437 Prospect, that's submitted. The first case for argument is Adler versus DLJ Mortgage Capital.
Good afternoon, Your Honors. May it please the court. Greg Verrilli of Knuckles, Komazinski, and Manfro for the cross appellants, DLJ Mortgage and Celine Finance. I just want to start first by addressing the Court of Appeals' recent decision in Freedom Mortgage versus Engel, which was decided right before this appeal was perfected. It's submitted that this decision is completely on point with the facts and is controlling here. There was a prior foreclosure action that was commenced by DLJ's predecessor, and there's no dispute that there was a voluntary discontinuance of that within the 6 years of commencement of the action. Consequently, under Engel, there's no additional, evidence of the acceleration that would be required aside from the discontinuance of the action itself. The plaintiff appellant here, however, is just attempting to distinguish that case, this case from Engel, basically by saying that there was a notice acceleration based on the failure to cure the notice of default. As noted in the briefs, the initial brief and the reply brief by the cross appellants, that language that is included in the standard default notice is not sufficient to accelerate a loan, and that was addressed in Engel. Part of the decision included the Vargas decision that came from this court, and in that case, this court initially found that would be enough to accelerate the loan, but Engel reversed that and held that it wasn't. So basically, it's our contention that Engel controls and that there's no additional, analysis that needs to be taken. However, even under the pre-Engel standard, it's submitted that that there was the acceleration of the loan, and that the Supreme Court should.
Mr. Verrilli, why do we have to consider anything that came before the most recent Court of Appeals case?
I don't think you.
Honestly.
I don't think you. Right. I don't think you do.
Right. Those issues were they were floating around in the intermediary appellate courts with varying results, and the appellate and the Court of Appeals decided those issues, right?
Correct.
We don't.
So you're right, Your Honor. So based on, I'll rest on the remainder of the arguments that are in my brief, and I'll let the court make that decision.
All right. Do any of my colleagues have any questions? Thank you, Mr. Verrilli.
Thank you very much. Have a good day, everyone.
You too. The next case is Kyriakos versus Hyung Jung.
Good afternoon. Yes. You see me okay?
We can hear you. We can see you. Go ahead.
Excellent. Good afternoon, Your Honors. May it please the court. My name is Stephen Fairchild of Fairchild Law LLC, arguing for the appellant. The appellant appeals the decision of $86,000 in attorney fees and $12,000 in sanctions by the family court because this decision was factually wrong, legally wrong, and procedurally flawed.
This is before we get to your arguments. I
Yes.
just want to make sure that I understand, because it was 86,000 with an adjustment downward. So I think the amount is at 66,000 now, or that's not agreed to.
I don't believe that's agreed to. I don't think that was spelled out in the judgment, Your Honor.
It wasn't, but there needs to be an adjustment for any fees that were allocated to the Article 8, right? That was
Yeah,
the decision.
That was in the order, yes.
Okay. All right. You can proceed with your legal argument.
Okay. Thank you, Your Honors. And first, it is factually wrong. The underlying case was a child visitation case, and the father, the respondent, decided on his own initiative to suspend visiting the child. And second, it was legally wrong. The lower court did not find that Ms. Kim's actions warranted sanctions solely under 22 NYCRR 1301. Instead, it simultaneously applied that law with DRL 237 and Articles 6 and 8 of the Family Court Act. And this is a crucial distinction because if it applied DRL 237, then it did so incorrectly. That respondent's brief even agreed that the purpose of DRL 37 was to provide the authority of the court to direct a party to for the less affluent party or spouse or parent to receive appropriate legal services, money thereof from the more affluent party. The policy was not to shift the money from the non-money spouse to the moneyed spouse, and it's quite the opposite. And that's exactly what the lower court did. Here, the respondent has a net worth of about $100 million. Meanwhile, the appellant, Ms. Kim, is an unemployed single mother who lost her job during the COVID pandemic and survives by ever-increasing credit card debt. So not only did the court violate the policy of DRL 237, but it presented her an undue hardship. And finally, the procedural flaw is what Your Honors just acknowledged, that there needed to be an adjustment. The adjustment was not set forth in the order. And for those reasons, we believe this case should be remanded back to the lower court.
Thank you. All right. Ms. Thorpe?
Good afternoon. May it please the court. I represent the respondent on this appeal, Kyriakos Lupus. Rule 130-1.1 alone, excuse me, provides ample authority for the family court's order and for affirmance by this court. The appellant's argument that there should be a reversal because the family court applied domestic relations law 237A in addition to Rule 130 to the facts of this case is really, and argues that the order is not consonant with the policy underlying the domestic relations law statute. That's really a straw man argument. It diverts attention from the frivolous conduct of the appellant to the relative financial circumstances of the parties. The respondent moved under Rule 130-1.1. He did not move under the domestic relations law. Rule 130 specifically addresses, the types of conduct that the appellant engaged in repeatedly in this case from the very outset of this case. And over the course of an entire year, the appellant engaged in conduct that falls within the scope of each of the three prongs of the definition of frivolous conduct under subdivision C of Rule 130-1.1. Starting at the outset, she prolonged the proceeding by making materially false statements, which the family court found she did. She prolonged the proceeding by disobeying 3 court orders. She engaged or made numerous motions that were completely baseless, had no basis in law, without any argument for extension or modification of law. And she engaged in what the family court itself termed, quote, a comprehensive pattern of harassment, close quote. Now, nothing in Rule 130 requires the court to consider the financial circumstances of the parties. It's directed at conduct, not finances. And if the rule were different, if consideration of the respective finances of the parties were to be required under Rule 130, I submit that the less affluent litigant would always have an advantage. It would have an advantage because they could engage in harassment or other frivolous conduct without the fear of financial consequences, whereas the more affluent litigant could not. So that seems to me to be, that would result in not only an unfair policy, but one that would not be wise from the administration of justice point of view. Now, the appellant has also argued that there's no connection between the fees awarded and the conduct. In fact, as the family court pointed out in its decision, the appellant's conduct necessitated otherwise unnecessary court appearances, multiple court appearances because of her conduct. There were and necessitated consequently numerous communications between the respondent and counsel. It required responses to all of the meritless motions that she made. And there were the costs of preparation of the motion under Rule 130.
Ms. Thorpe, I'm going to ask you to wrap up your argument because you're out of time.
Oh, I'm so sorry.
No need to apologize.
I'll just say one thing apart from the fees. Appellate has attached to their reply papers a declaration, an affidavit from the appellant, which is completely improper, and we didn't have a chance to respond to it. I will say that the facts alleged in there were not before the family court, and they're wrong, and I could prove that they're wrong based on the record, and I ask the court to disregard that declaration.
Mr. Fairchild, you have 1 minute for rebuttal.
Oh, thank you, Your Honor. It is true that the respondent did move under Section 130-1.
Let me ask you another question. I just want to get it out of the way. You know, in
Sure.
terms of having an affidavit of your client attached to the brief, we can't consider that. You'd concede that, right?
Okay, yeah, yes, Your Honor.
Okay, good. So that's out of the way. Go ahead.
Okay, so, but yes, it is true that the respondent did move under 131.1. We agree to that. However, the court voluntarily applied Domestic Relations Law 237. This is not a strongman argument. This is not an unfair characterization of the order.
Here's a question. If we were
Yes.
looking at this, would we be entitled to affirm this just on the sanctions rule? Couldn't we do that if that's right?
I don't believe that's what the lower court was doing, Your Honor.
No, I understand. I didn't ask you that. I asked, do we have the right to look at this and just affirm on the basis of the law that we think is applicable? Assuming we agree with you.
If that is your reading of the law, that's your, I'm sorry, if that is your reading of the order, that's reading the order, Your Honor, but I have a different reading of the order, Your Honors.
It's even if I agree with your reading of the order, can we affirm on a separate ground or on one of the grounds asserted? That's all I'm asking. Just
Okay.
it's a matter of authority.
No, Your Honor, because under the Martinez case, even under 131.1, the order still needed to specify, still needed to match the attorney fee award with the frivolous conduct. And this court did not, or sorry, the lower court did not do that in this case, Your Honor.
Any further questions, colleagues? Thank you. Thank you. Thank you both.
Thank you.
Thank you.
Okay, City Club of New York versus the Board of Standards and Appeals.
Good afternoon, Your Honor. This is Eric Lee for the City BSA and DOB, and I have 2 minutes reserved for rebuttal. Is that correct?
That's correct.
Thank you, Your Honors. Supreme Court erred because it invented its own zoning requirements for this project. In defiance of agency deference, the plain language of the zoning resolution, and settled precedent of this court and the Court of Appeals.
Counsel, this is Judge Kern. Let me ask a question. Why should the R8 square footage be included for purposes of calculating the permissible bulk distribution of the tower when the tower is totally prohibited in the R8 zone? What is the sense of that?
Your Honors, a couple of things. First of all, the plain language of the bulk distribution rule says that the rule applies everywhere in the special district, and even the Supreme Court agreed with that. And the second thing is, the City Club is just wrong that the R8 district has, that the bulk distribution rule has no effect in the R8 district. And I'll just take the R8 portion of this particular split lot. The RA portion allows for over 127,000 square feet. And just to give that a human perspective, that's just under 3 acres and about 2 2/3 football fields. Anyone with that amount of floor area can easily build a tall building. And in fact, Excel showed this in the modeling in the administrative record. Excel showed that without the bulk distribution rule, even someone with just the RA portion of that split lot can build a 30-story building.
But Councilor,
because of the bulk,
if that's true, why did you use the bulk distribution rule to allow extra space, including the RA portion of the building? If you're saying it's not necessary, why was it done to reach the bulk distribution ruling that you reached?
well, just to be clear, I represent BSA, so these are not my plans. We approve these plans as rational, but
your ruling about what is or is not permissible. What's being challenged here is the ruling of the BSA.
that's correct.
What bulk distribution was or was not allowed. When you came up with your figure, the BSA, as to what was or was not allowed, you included the R8 footage.
We did.
Towers are not allowed, and that's my question for you. Why would you include that if it's not allowed?
Towers are actually allowed in the RA district. As I was explaining, the bulk distribution rule does have an effect. Excel's model showed this, because just the RA portion alone allows any property owner, even if Excel only had the RA portion, they have about 2 2/3 football fields to work with. That is a lot on that tiny little lot to easily build a tall tower. And so Excel's modeling showed that without the bulk.
Let me stop you for a minute, because the
Sure.
lower court decision said that there was a difference of about 6 floors, right? Is that true or it's not true? I mean, there are tall towers and there are taller towers, right?
Well, I think the difference in floors is sort of depending on whether you count the mechanical spaces, which are not counted as floor
We're going
area.
to get to the mechanical space separately. Right now,
Sure.
we're just talking about whether it should have been treated, whether the BSA correctly interpreted the zoning resolution to deal with the special district without otherwise treating it as a split lot, right? I mean, isn't that,
Right.
it's just an interpretation issue, or is it?
Well, it's actually it's about the consistency of applying the split lot rule that this court endorsed in Beekman Hill, and that rule is that if a zoning rule applies to both portions of a split lot, the internal divide is disregarded and compliance is treated based on the unified lot, and that's what happened here. And so I think City Club keeps trying to say, well, this building would actually be illegal if it was under all a C47 and R8. But I want to break down exactly why that's the case.
What the argument is, though. Wait, I'm going to go back, because I don't think that is what the argument is. The question is, how tall does this building get to be? And if you include the R8 footage, it gets to be taller than it would otherwise be. So that's the question that needs to be determined, which is not what I think you just stated.
Well, that's actually not accurate, Your Honor. It does not get to be any taller than it has to be. It is undisputed that for every square footage that is below 150 is not being used above 150. The reason why City Club keeps saying that is because they keep ignoring a whole part of the split lot, but you can't do that. You can't pretend that this split lot doesn't have 2 portions, one of which happens to be in C47 and the other portion happens to be in R8. The reason why this building, if it were all in C47, would not work is not because of the bulk distribution rule. In fact, it is undisputed that it would actually comply with the bulk distribution rule. Again, everything that should be under 150 feet is 150 feet. The project would not work if it were all C47 is because it wouldn't comply with another rule called the tower coverage rule. And that's because that rule says that any building has to be between 30 to 40% of the total ratio of the C47. So obviously, if the entire zoning lot were C47, the tower would need to be wider, and that would drag the building down. So what City Club is not telling you is that their big issue is actually with the tower coverage rule, but they know that they can't attack the wording of the tower coverage rule. So they're trying to say, no, the bulk distribution rule is the problem. But they're ignoring the fact that the drafters said they want the tower coverage rule to only apply to C47 portions of this special district. but they want the bulk distribution rule to apply everywhere. It says within the special district. And it's not just sort of some throwaway language. City Club keeps pretending it means something else, or they say it's actually a Scrivener's error. No, it is a textual convention that the drafters used for this chapter, for the chapter of the special district, to say, where does this rule apply? And the fact that City Club cannot give you a single answer what it's supposed to be. They give you 3 different answers and they say, well, you can just ignore it if you want to. That is not.
Council, one will get to apply to one portion and the other rule gets to apply. Isn't that inconsistent? That you can say bulk distribution applies to everything, with the tower coverage rule is only going to apply to the C47 portion.
That's not at all consistent. That's not at all inconsistent, Your Honor. Not only because the plain rules say that, but because we know that they made a choice. The drafters had the rule that the City Club loves to cite is 23-261. That rule is very specific. It includes both concepts of bulk distribution and tower coverage in the same rule, and they have a very interconnected way of working. For every 1% decrease in the tower coverage, there is a corresponding increase in floor area. That's not how these 2 rules work here. And the drafters, when they said, oh, we like that rule, they said, we're going to apply that rule only in subdistrict A of this special district, and only if certain floor area criteria are met. And then on top of that, they said it has to be on certain streets. So specifically, really in this area of Broad, that they did not make those choices with the bulk distribution rule or the tower coverage rule. They said everywhere else, other than this very specific area where they wanted to maintain a specific look along Broadway, they said bulk distribution rule applies everywhere. And this is not only how the DOB and the BSA have applied this rule in a previous instance, it's the most natural reading of the rule. City Club wants you to pretend that the textual convention, the first 4 key critical phrase, they want you to pretend that doesn't mean anything. That is not a, sorry, did I?
You just exceeded your time. So, but I think we understand your argument on this issue. We're going to go to the Extel now, and I'm going to let them carry the argument on the mechanical space, which we have questions on as well. So, Mr. Cyrulnik.
Thank you, Your Honor. Would you like me to go straight to the mechanical spaces?
Yeah, I personally would, if my colleagues are amenable, because that's the secondary issue we have to address. And I have something that I just don't understand, and maybe you can straighten it out for me. All right, I read the BSA decision, and it seemed to say that they were going to interpret what the mechanical rule pre-2019, what the mechanical space zoning resolution provision was, but that there was a third issue about this owner's particular use or particular claim that they needed all that space for mechanical equipment, and that was going to be sent back to the board to determine. Did I misread that?
Sure, Your Honor. Let me just clarify. There was a third issue that was raised with respect, as you said, with respect to this particular owner's use of the mechanical spaces. That was separately submitted to the board. That was separately resolved by the board. And actually, just yesterday, Your Honor, there was an Article 78 filed against the board with respect to that issue. And Justice Rathauer.
Which one of you? By you or by Mr. Lobier?
It was filed by another appellant similar to Mr. Lobier, another challenger. Mr. Lobier did not raise that issue. It was raised by another entity called Landmarks West. That was an Article 78.
Just because this is a complicated case, and although we've given all of you a lot of time, we have a lot of questions. So that issue, the issue of whether the use of the mechanical space was necessary in this particular case is not part of this Article 78.
That's right, Your Honor. It's not part of this Article 78. And just for the court's update, it was decided yesterday, and it was. You
don't need to know how it was decided. I assume we're going to get that. Okay. Yeah.
So part of this argument, I've lost the thread here a little bit. Why isn't the issue of the mechanical space part of the argument before us today?
The only issue that was raised by the particular respondent here, the one who filed the Article 78 City Club, was the vertical height issue of the mechanical spaces. They did not raise the separate issue of whether or not equipment was properly filling out the mechanical spaces that were designed here. And so the issue that the mechanical space issue before this court, and that was before the lower court here, was simply whether or not there was a regulation that limited the height of the mechanical spaces at issue. And with respect to that issue, the
They didn't make
BSA
the argument below that the court decided it on, which is that the board should pay some attention to what the mechanical space is being used for, and make some inquiry into that. That argument wasn't made below.
No, Your Honor, that was not the argument made below. It was not even really the core basis of, as we read Justice Ngoran's decision, the core basis of his decision. He made an offhanded remark, but it's one that that really encroached on the separate issue that was presented to Justice Racco in a separate petition. But no, that was not the argument they made. The argument they made was that there needs to be a height limitation, a vertical height limitation, irrespective of where of what equipment's in the room, a height limitation, which indeed is what was imposed by the legislature in May 2019. It is a height limitation on the mechanical spaces. How high can those floors be in order for them to be exempted from the calculation? And they, you know,
position is that we should not be deciding the issue of whether or not an appropriate inquiry was made into how much mechanical space the mechanical equipment needed.
That's right, Your Honor. That was not an issue that was presented below. It was not an issue that was in this proceeding, and that it was actually an issue that was earmarked by the BSA and by the challenger there for a separate proceeding, which was resolved yesterday in our.
So our look at the mechanical space issue is just whether the zoning resolution, either by expressly or by implication, has a height limitation.
That's correct, Your Honor. And with respect to that issue, there were, I'll briefly state that there were 3 reasons why there was not, and it's consistent with precedent that addressed the issue. 1, the plain text of the zoning resolution includes no such limitation anywhere. I don't think there's any way of really disputing that. The second reason is that the BSA's own extensive precedent addressing this issue consistently found that there was no such limitation. And the third reason, Your Honor, is that it's specifically because of that, as the court had previously said, if this is an issue that the community doesn't like or that someone doesn't like, it needs to be addressed legislatively, not through the courts. And so that's exactly what happened. And the legislature imposed in May 2019 a height limitation on the mechanical spaces.
The court below specifically said that he wasn't going to get involved in whether that was retroactive or not. Do we have any dispute about whether that's retroactive?
Your Honor, I don't think we have any dispute about whether that's retroactive. What the court below interestingly said was he wasn't going to get involved in the semantics of how that change impacted the analysis. But of course, we think that change, although even with the plain language and the extensive precedent grounds, it was clear enough. We think that change certainly puts the nail in the coffin on that issue. There'd be no reason, and this court has consistently stated that it needs to credit changes, it needs to credit new legislation as having meaning. And to impose such a new limitation in May 2019 prospectively, which is not something that is disputed, is something that we think confirms that the operative regulation for purposes of this project is one that did not have such a limitation. So I'm happy to address anything else on the mechanical spaces, but we do think that that is, it limited to the question of whether there's a zoning resolution that imposes the height limitation. We don't even think that the court below's order is sensible because it purports to impose a limitation, but it's not even clear what that limitation is. The legislation that was actually enacted imposed very clear limitations as one would expect. It said 25 feet for this. It said exactly what it was imposing. The court below just said there is a limitation. He didn't ground it in any text and didn't grapple with the change in the legislation. So we think on that issue.
Counsel, this is Judge Owing, but that limitation that you just talked about in terms of the mechanical height, that was in May 2019. When your client got his project vested, it was before May 2019, correct? And at that time, correct, at the vesting point, there was no height limitation.
That's correct, Justice Owing. That's exactly right. There's no dispute that was a prospective change. It was hardly fought at the legislative level, and it clearly was not affecting this project, which vested earlier, which is why this issue was resolved that way at the BSA level.
Well, arguably, I guess, arguably, you know, to have retroactive effect would be really, it would cause a lot of trouble retroactively applying a height limitation like that, because you already have projects already started, and that to do that that would be reversing plumbing situations, and that's not good.
Yes, Your Honor, it would be extraordinary, as would application of the second part of the decision below, because the implications of these decisions reach far beyond this particular building, which was done, you know, by the book in compliance with this court's guidance in Beekman Hill as to how you apply the particular regulations. And as Your Honor just pointed out, with respect to there not being a height limitation on the mechanical spaces, and to rule otherwise, as Justice Engoron did against the unanimous BSA, has implications for many buildings and, you know, billions of dollars that have been invested in buildings, including this one, in reliance on that.
All right, Mr. Cyrulnik, your time is up. You'll have some time on rebuttal. All
Thank
right,
you, Your Honor.
Mr. Lobier, you may proceed.
Yes, Your Honor. So, good afternoon, John Lobier for Respondent City Club. So the bulk distribution rule says that at least 60% of the total floor area permitted on a zoning lot has to be below 150 feet. That 60% forms a base. There's 40% left for a tower. Together, they fit within an envelope whose size is limited by the district floor area ratio. Now, which in this case is 12. It's the highest density in the city. This isn't speculative. It's not the city club's preference. It's in the text. And what happened here is it's because of this building's particular unique split lot location that much of its base is outside of the C47 envelope. And as you were saying a few minutes ago, this allows it to be 96 feet taller than if it were entirely in C47. So, and it's much, much taller than it could be if it were in R8. And let me just respond to what Mr. Lee said.
Counsel, this is Judge Oing. How does the Court of Appeals recent case in Peyton affects this or impacts your argument? Because I was on that. I wrote that decision, right? And you were arguing that case too, if I recall.
Yes. Well, needless to say, I wasn't very happy with that decision. And I don't know if you've seen the recent articles in the Law Journal
What
about.
happened with my decision or the Court of Appeals decision?
Oh, I was very happy with your decision. I was not so happy with the Court of Appeals decision.
Right. So how does their decision impact your argument? Because it's almost analogous in terms of what happened there, right?
Well, on it.
Close enough.
On its face, the Court of Appeals in that case did not change the law one bit. They reiterated that where there's a pure question of law, there should not be a deference to the Board of Standards and Appeals. So I guess it comes down to, okay, what is a pure question of law? And I don't think it changed the law. I hope it didn't change the law. It didn't purport to change the law.
Counsel, but that's the point. What you're arguing here is you're arguing about in terms of what one side of the lot is permissible to use in terms of space or height space that the other lot has, which is very similar to the Peyton argument, which is talking about open space. And I agreed with you when you made those arguments that, yeah, that whole 8,000, I forget how many square feet, can't be used to calculate the open space. We tried, but
right.
And that was a straight statutory interpretation too. That I took the position, the majority took the position that it was a straight up statutory interpretation that the BSA was not entitled to deference.
Right.
And
well, honestly, my view is that was wrongly decided. But what can I say? I think, but also. I was going to get into the question of deference because I don't think it's the case that after Peyton, the Board of Standards and Appeals walks on water. I do think that there are issues about the Board of Standards and Appeals, and indeed, in
Mr. Lobier, let me hit it right on the nail. what is it that in this case that's straight up strict statutory interpretation that I don't have to look at any facts at all to decide this issue with respect to the lot issue, the bulk distribution?
Well,
I don't want to look at any facts. I can just look at the statute because that's what the Court of Appeal says. If it's a straight up statutory interpretation
Right.
without looking at any facts, we got the ball. So
Right.
tell me, without looking at any facts, what is it about this bulk distribution or any other zoning resolution that allows us to agree with what you put forth?
Sure. The rule is clear that it applies within an envelope, and I submit that the phrase within the special district was inadvertent. And just like in Beekman, which is much cited here, in addition to the split lot issue in Beekman, there was a second issue in that case, which had to do with whether you could build a standard tower or whether it had to be a tower on a base. And the Board of Standards and Appeals in that case said, well, forget about the literal language of the statute. We think it was inadvertent draftsmanship. And so we're going to ignore the literal language. And this court, the First Department, deferred to the Board of Standards and Appeals. It affirmed the ruling, but not without questioning it. It went into a detailed analysis of the statute and how it was inadvertent draftsmanship and why the Board of Standards and Appeals ruling was actually correct on the law. And I think if you do the same thing here, you will find, I mean, even under an arbitrary and capricious standard, the reasoning that the Board of Standards and Appeals gave makes no sense whatsoever. They said, we're not going to look at the absurdity canon, but we're going to, if you compare buildings within the special district and buildings outside the special district, and if you compare buildings built within the special district after this provision was passed, after 1993, you will find that those buildings are shorter than the buildings built before. They're shorter than the buildings built outside. And so, but that's totally irrelevant. If anything, it proves our point. I mean, we're saying, yeah, that's right. The rule works. When it does what it's supposed to do, it reduces the size of the building. But what about in this unique situation? And, you know, you do, I mean, any ruling on a question of law, of course, you have to look at the facts and apply them to the law, but there's no policy involved here. It's just a matter of reading the statute and understanding what it means. So that would be my answer on that point.
What about the?
If I may, can I add just
this is Justice Kern. What about the fact that what the BSA is saying is that the bulk distribution rule applies throughout the special districts. If you look at the plain language, that's what it says. What is legally incorrect about that interpretation that they are giving, which is that there's nothing in the statute that limits the bulk distribution rule to not applying in a C8 zone?
Well, but the entire concept of it, it's very clear what it was doing. And
going now to some intent, but if we're saying that they're allowed to read the plain language, what is wrong with their plain language interpretation?
Well, I would submit that those three words cannot carry, that they contradict the purpose of the statute, which is not our preference. It's plain in what the statute says. It says 60% has to be below, 40% above, and now you're taking that 60% outside, putting it somewhere else where it's totally irrelevant, and negating the rule. For each square foot that you take out of C47 and put into R8, your tower can grow by 1 square foot. And at the limit, if you had a big enough R8 portion in your lot, you could only have tower in C47. That's obviously, the statute intended 60-40. It didn't intend 100% tower. And if I may say one more thing about deference, in 2017.
Mr. Lopier, I just want you to know, because you were concerned about the 8 minutes, you've already exceeded it, but I'm going to let you finish your argument.
Oh, thank you very much. So in 2017, the City Council held a hearing on the BSA, at which the head of the Governmental Operations Subcommittee said, let me find my quote here.
You could paraphrase it because you're
well, anyway, basically he said for years, people have alleged that the BSA is captive to the real estate industry and that they are circumventing the zoning resolution. And they had a hearing, they passed a law, but it didn't really do anything substantive. It mostly had to do with variances and creating greater transparency and accountability. So
you don't think we should be that deferential?
Well,
okay.
I mean,
I understand your argument. I honestly, it's my role to kind of move the time along. All right, so let's hear from Mr. Lee. You have 2 minutes.
Thank you, Your Honor.
Okay.
I'll start with Peyton. We agree that Peyton didn't change the law. It reaffirmed that courts defer to the BSA unless the statutory text, and I'm quoting now from the decision, resolves the dispute on its face, or if the challenger's interpretation is compelled by the text. That is not the case here. Mr. Lobier confirmed during this very oral argument, he cannot give you a plain language reading of that text. He has to use the words envelope, ratio, base, tower. That's nowhere in the rules. And by the way, that's nowhere in the legislative history, to be clear. Mr. Lobier, City Club, does not dispute that Excel is allowed to comply with the bulk distribution rule with an entire other building on its lot. There is no requirement that a building.
This is Judge Joy. So what you're saying is it's not straight up statutory interpretation. This is a statutory interpretation that requires factual considerations. Right? That's what you're saying.
Well, this is absolutely.
It's not straight up. I got to read the statute and decide whether or not the BSA got the statute right.
Well, yeah, City Club can't do that. And this is a case where it is the core competency of the BSA to address how does the zoning resolution apply to a specific zoning. And by the way, we are following a consistent approach. We're not circumventing the law. We are literally applying a long-standing approach that this court confirmed and endorsed in Beekman Hill, which is when it comes to split lots, which are its own category, they are unique. They have their own chapter of rules, in fact. You go rule by rule, and if the rule applies to both portions, it's assessed against the entire lot. And having a consistent approach, one endorsed by this court, cannot be irrational. In fact, it is what ensures predictability in the zoning process. The ad hoc system that City Club pushes for is what would lead a zoning board to go astray. And so,
all right, we understand your argument, Mr. Lee. Forgive me, but you're out of time. Let's hear from Mr. Cyrilnik.
Thank you, Justice Gish. I will try to spend my time wisely. I just want to address one thing that Justice Owing was asking about, and then one thing that Justice Gish and Justice Kern were asking about. Let me start with the Justice Owing questions, because those were most recent. With respect to Peyton and the last question that he asked, that's exactly right, Justice Owing. With respect to the Peyton rule and the application, it's not just the appellants here who are saying that you need to apply the facts, the regulations to the facts over here. Mr. Lobier himself admitted it. He just admitted it in response to your questions, Your Honor. When you asked him to identify the statute that can be applied without that additional component, and it's a major component, he was unable to. Instead, he said, it's really, you have to look at the effect, an envelope, and as Mr. Lee said, the word envelope appears nowhere. This is a construction that Mr. Lobier prefers. He sort of made his own version of it, and the court below adopted it, but it's certainly not based on the plain language of the statute. And he even, Mr. Lobier even went as far as to say that he thinks the plain language, which actually does not work with that construction, may have been inadvertent. And that's just not remotely close to the standard that needs to be met to depart from the very, very limited circumstances where Peyton permits a court to not defer to the BSA, in particular with a unanimous decision like this that was made after a very, very comprehensive record was developed. This is clearly within the spectrum of what Peyton said is deference is still appropriate where the question is one of specific application of a broad statutory term. That's even without facts. And here you have facts that are critical because of the nature of the zoning lot at issue. And so we think it clearly warrants deference. If I could just briefly address the questions that Justice.
If you can do it in 20 seconds, sir.
Sorry.
It's a complicated case. I don't think any of you should have the expectation that it's going to be won or lost at oral argument. We have your briefs and we have the record on appeal, and we're going to give it careful consideration.
I understood, Your Honor. I just wanted to address the questions that you were asking my colleagues. I didn't get to address the bulk distribution rule during the opening, so I'll make it as quickly as I can. Justice Gish and Kern were asking about the application of 8234 to the whole lot. I think it's critical to recognize that even the court below agreed with the appellants here. The court below at R9, either R8 or R9 of the record, said it's R9, we said that the 8234 applies to both portions of this split lot. And he said, well, yes, it does. That's a quote. That's not Mr. Lobier's position, but that was the court's conclusion, the BSA's conclusion, the DOB's conclusion. That's because it's absolutely true. 8254 allows for towers to be built on the R8 portion. And that responds directly to Justice Kern's question. You can have towers. It's just that we're hearing over and over again in Mr. Lobier's briefs that you can't, but it's just not cited to anything. You can have towers there. And that's why 8234 clearly applies to the entire lot. And what Beekman Hill, this court said in Beekman Hill is, okay, if you have a provision that applies to both parts of the lot, here's what you have to do. You have to do the calculation based on the entire lot. But when it comes to 8236, which indisputably applies to only one portion, that, like any other provision that applies to only one portion of the lot, has to be calculated differently. And so there's nothing here that happened that was inconsistent with the way that this court directed, based on 7702, directed the BSA and the DOB to act in connection with the split lot.
Thank you. Thank you all for your arguments.
Thank you.
Your Honors.
People of the state of New York versus Merkin.
Yes. Good afternoon, Your Honors. May it please the court, Lawrence Orloff on behalf of the Sandalwood appellants, Sandalwood Debt Fund A, B, and Hudson Investments. Your Honor, I'm arguing on behalf of three entities which are funds of funds, managed by Martin Gross, who is an affiant in the record in this case, and who is a fiduciary for hundreds of partners of his funds of funds who look to invest in other security investments. And this case is particularly important because in his practice, as you could imagine, and as in most practices, one of the things you rely on when you become a partner in an entity is what the governing terms of the agreement are in that entity. In this case, my clients invested since 1996, at least some of them, approximately $32 million in cash into an entity known as Ascot Partners, which is the subject of this appeal. And at the time of the Madoff implosion, I'll call it that, in late 2008, they had a capital account balance among the three of approximately $14 million.
Let me just stop you there, all right? Because those capital account balances were based upon the fact that the Madoff entity was reporting that there were profits, and in fact, there were none. In other words, the accounting on the books didn't reflect the reality of the money outside. There was no money backing those numbers up. They may not have known that, but we know that now.
That's correct, Your Honor, but as it turns out, that wasn't known, and B, the fact of the matter is, and that's what distinguishes this case from the normal Ponzi cases, that Ascot Partners itself was not a Ponzi scheme. Even the court below acknowledges that, although it says it's difference but not a distinction. It is very much a
Well,
distinction.
one of the things that they talked about, and it was a little unclear to me in the record, the receiver kept saying that virtually all of the assets of Ascot were invested with Madoff. And I didn't see anything either in your or the other objectants' papers that disputed that had a different split, that said any part of Ascot's investments were in non-Madoff Ponzi schemes.
Well,
Is that true?
it's true that virtually all of the investments were put into Madoff by Ascot, but Ascot was a partnership in which Mr. Merkin at the time was the general partner and the managing partner, and there became hundreds of limited partners, all of whom signed all of the, and the one that applies here is the third amended limited partnership agreement. And the limited partnership agreement was between Mr. Madoff as managing partner and general partner, Mr. Merkin as general partner,
Right.
and the various limited partners. And this agreement is not being challenged on the grounds that there was any fraud involved as among and between the partners in Ascot. They all signed up, they all put their money in, and they all understood and agreed and anticipated that in the event the partnership was dissolved at some point, it would be dissolved in accordance with the partnership agreement and in accordance with Delaware law, since it was a Delaware entity.
Does it make a difference that here it wasn't the management of Ascot that was liquidating here? They were put into equity liquidation by the Attorney General. Is that a difference that we should be concerned about or not?
Not at all, Your Honor. And in this sense, it does not impact the effect and conclusiveness of the agreement to which all the partners were bound. An equity receiver was put in. Mr. Merkin, as general partner, consented to it, but the receiver was put in, and although he's called an equity receiver, and I understand the word equity floats around in this case very significantly, the fact of the matter is he was put into this matter as a receiver in accordance with the agreement of the parties and the order appointing him, in fact, and this is in the record on page.
Counsel, I'm going to interrupt for a second. If there's no profits that were ever generated by Ascot, which there were not, since Madoff never generated any profits, it was all fictitious, why shouldn't the money be distributed equitably? Why would there be any other way to distribute where there are no real profits?
Your Honor, the question in this case is not how the money in a vacuum should be distributed and what would be an equitable way, although we don't agree that it would be equitable. My colleague, Mr. Ofsis, will follow up on that. The point here is there is no reason why and no precedent for ignoring the limited partnership agreement. The limited partnership agreement calls.
Counsel, I'm asking a question. Why should the limited partnership agreement apply? Isn't that intended to apply where there are real profits that need to be distributed? And you've agreed, these are the profits and this is how we agree to distribute the profits, where in this case, there are no profits to distribute. So why should that agreement still be in place?
Because the limited partnership agreement as among these partners should govern their relationship. The fact that the money was invested in another entity that was itself a fraud should not impact the relationship between these partners. When they entered into this partnership, they all knew, and it's in the offering papers that are part of the record that they all signed, that there were risks that this investment might not turn out right. There were risks of potential mismanagement on the part of third parties to whom the assets were given. These are the expectations.
Well, this was more than
mismanagement.
Yeah, this was more than mismanagement. I honestly, I mean, if we're going to be fair about it, this was everybody was defrauded up and down, right? Every single investor, Ascot, just right down the line. Yeah.
Well, to say that it's mismanagement is one thing. To say that the partners as between each other should not have their agreement honored because someone else committed a fraud, and it was not Mr. Merkin who was charged or admitted to any fraud here. It was Mr. Madoff, and indeed Ascot itself is the victim of a fraud, not the perpetrator of the fraud. And when that's so, under the established New York case law involving partnerships that we've cited to you in our brief, the partnership agreement should be honored, and calling this receiver an equity receiver does not change things. As we pointed out to you, the fact that he was appointed as an equity receiver does not give the court or him the right to disregard the clear terms of the partnership agreement, which defines the capital account, which explains how capital accounts are built.
We understand your argument. You're out of time. It seems to be my refrain today, but we have a heavy calendar. So let's hear from Mr. Office, you're the other objectant in this case. Go ahead, representing the other objectants.
Good afternoon, Your Honors. May it please the court. Arthur Ralph says for the objector Geraldine Fabricant. We join in the points being made by the Sandalwood appellants, and the most notable of those points is that on the facts of this case, the court below had no authority to allow the receiver to override the distribution terms of the limited partnership agreement. And what I want to do—
Response to Tremont and the decision in Tremont as authority to allow exactly what occurred.
Yes, the difference is that in Tremont, the investors entered into a settlement agreement that superseded the partnership agreement. And for that reason, there was no issue in Tremont as to whether the partnership agreement was being overridden by a receiver.
Didn't the parties in this case agree to the equity receiver?
The enterprise in this case agreed to the equity receiver. It didn't agree to
situation.
It didn't here. None of the investors agreed to a particular plan or form of distribution. No one here agreed to replace them. I'm sorry, Your Honor.
Agreed to a receiver.
Here the general partner agreed to the appointment of the equity receiver. The individual investors did not object to that, but the receivership order makes clear that any distribution needs to be approved by the court. So clearly the expectation was that the receiver would have to give good reasons for his plan of distribution. And
right. I think that nobody disagrees with that, but here's my question to you, and I keep going around in circles on this, is that you have somebody who's appointed an equity receiver, and yet the position of you and Mr. Orloff is that they can't do equity. They can only propose a plan that is in accordance with what the agreement says, which actually is a legal argument. That's a legal argument. So what's the purpose of calling them an equity receiver if they don't have equitable powers? I just don't, what's the purpose of it? Why couldn't they just be a receiver in law?
They have equitable powers to a point. There are limits to the extent of the equity powers. No one is saying they can act lawlessly. At some point, an equity receiver needs to follow the law.
Right, and the law here, and the order was here, is that you'll come and you'll ask the court for approval of any plan of distribution after you marshal the assets.
And nowhere did the receivership order say that the receiver could override the limited partnership agreement.
It didn't say it couldn't either. It didn't say it couldn't.
It's been clear. It's been clear for a very long time, Your Honor, in case law, both in our Court of Appeals and as far up as the U.S. Supreme Court, that a receiver. But let me put it a different way, that a court, even sitting in equity, must honor a contract unless there's been fraud, accident, or mistake. And that's in the formation of the contract. There is no issue of fraud, accident, or mistake in the formation of this limited partnership agreement. As
let me ask you another question, because I know you were sort of tasked with arguing that even if the receiver could do equity, that the plan proposed is not fair and reasonable. Do you want to address that?
Sure. The basic problem here is that the court was tasked with the job of weighing the equities, and the receiver had the job to make a case for the equities as he saw them. And the problem is that neither one of them did their job. The receiver simply said over and over again that his plan was going to serve the interests of a majority, and as opposed to a small group who are trying to benefit themselves at the expense of that majority. The problem is that he didn't put in any evidence to support that. The only documentary evidence he submitted was his own affirmation, his own say-so, and he's just a lawyer like the rest of us. He's not an accountant.
But it flows from the plan, though. I mean, it's sort of a mathematical conclusion, no?
Well, but then it's just.
I mean, you have a certain amount of assets. You have $120 million, right? And you have to figure out a percentage of how it's going to be distributed. That's just math. So you figure it out, and you know, if you use the other formula, that the people on the top are going to wind up with more money than the people on the bottom with less money. I don't really understand that argument, but I'll let you address that as a question, and then we're going to move on to Ms. Archer.
Yeah, even if it's right that the people at the top are going to get more under the method that we propose, there is no unfairness to the others in the fact that that's happening, because the only reason those people have more money in their accounts at the end of the partnership is because they invested more money and left it in the fund for a longer period of time.
That's only if you believe that the entries reflected a reality of profits. Okay,
No.
let's hear from Ms. Archer.
Thank you.
Go ahead. Yeah, unmute yourself, please.
Apologies. May it please the court, Judith Archer of Norton Rose Fulbright for the receiver, Ralph C. Dawson, respondent here. The issue presented here is whether a New York court that has established an equity receivership to pursue recovery for fraud victims can order a distribution of recovered monies according to equity. The Supreme Court properly exercised its discretion to appoint the equity receiver for Ascot more than 10 years ago, upon request by the New York Attorney General, agreement of all the parties, and no objection by any investor for 10 years. Ascot was wholly invested with Madoff, lost all that investment in Madoff's Ponzi scheme. You questioned earlier about virtually all assets. There was a small amount that was not invested, but was in cash, and that was promptly frozen by the Madoff trustee when they brought suit to recover funds from Ascot under the avoidable transfer doctrine. The receiver was granted extremely broad authority. Mr. Orloff commented that equity floats around here. Well, it certainly floats around in the receivership order. The receiver was given all of the powers of the general partner under the partnership agreement, plus all the powers and authorities of a receiver in equity and a liquidating receiver under New York law and under Delaware law. And let's remember, the New York Attorney General brought this action under the Martin Act to pursue remedies in connection with the fraud. The receiver recovered more than $136 million for Ascot's defrauded investors. There would be no funds to distribute but for the receiver's efforts under the receivership order.
Well, that's what and of course, I mean, that's what they were there to do. So,
yes.
But that doesn't solve the issue of distribution, though.
Well, the receiver, after recovering the monies, did what the receivership order instructed him to do, which was to recommend a distribution methodology to the court. He believed that the net investment method, or the NIV, which calculated investor losses based on their actual cash in and cash out, and disregarded the fictitious profits. You were correct earlier, Your Honor, when you commented that those profits flowed from Madoff, those fake profits. They were on account statements. They were purportedly in investor capital accounts, but they were fictitious. They didn't exist.
Counsel,
so when the time.
This is Judge Owen.
Yes.
I'm sorry to cut you off, but I have a question I want to ask you. You know, the receiver here is essentially under the limited, because the appellant's argument is that this whole distribution goes against the limited partnership agreement. It's contrary to the limited partnership agreement. I think that's the thrust of the argument, correct?
Yes.
And my understanding from what you just said, The receiver here is essentially the managing partner, right?
Well, so the receiver had all of the authority of the managing partner plus the receivership order by the Supreme Court.
But essentially
additionally gave him equitable powers, and the court retains.
Right. Putting that aside, he substituted as the managing partner for the limited partnership, correct? I mean, that's essentially it.
Yes, except, Your Honor, this was a defunct entity. So the only thing that was happening was to recover money.
Because my next question is as
Yes.
I'm looking at the limited partnership agreement, it really grants the managing partner comprehensive authority as to how to handle everything. So that's why I'm leading into my argument about how you're saying, look, we're arguing about what the authority of the receiver is, and they're arguing that the limited partnership stands in the way of what the receiver can do. But if the receiver is essentially acting as a managing partner by way of a court appointment, well, as a managing partner, I understand a limited partnership law. If you ain't the managing partner, you don't have much say in how to run the business.
That's exactly right, Your Honor. And the receiver here, and we argue this in our briefs at length, aside from the equity power that the court has, not just the receiver, but the court, even if the limited partnership agreement controlled here, the net invested method would apply. It would require the receivers in the shoes of the general partner to undergo in advance of a dissolution, which is what's happening here, a process to determine the capital accounts of all partners, including by reasonably determining the fair market value of all partnership property, and that determination is binding on the partners. So under this process, the receiver, as in the Lipper case, the general partner would have to remove the fictitious profits in order to value the capital accounts. Otherwise, a distribution and dissolution takes place based on air, non-existent security trades that Mr. Madoff put in account statements and that were passed through Ascot to these investors. I recognize that Ascot was not itself a Ponzi scheme, but the impact is the same. The investors lost all of the fictitious profits. They lost all of their principal. The receiver has recovered enough to
They didn't lose the profits. They never had the profits. They lost
exactly. They never had the profits.
They lost their investment.
They did. They lost their investment, and there's not enough to make them all whole. So what Sandalwood and yes, Judge.
I'm sorry to cut you off.
That's okay.
Correct me if I'm wrong. Does the record reflect that Sandalwood actually recovered almost 95% of the money it invested, and even Fabrican actually got more money than it invested? Am I correct or wrong of that?
No, you're absolutely correct, Your Honor.
So they got their principal back?
Virtually all of it. One of the Sandalwood entities, Hudson and Miss Fabricant, both got more than their principal back. And the other two Sandalwood entities recovered 95%, if not more, of their principal. And so the fact that these investors, Mr. Orloff put a $32 million number, they invested for quite some time, that allowed them to take millions of dollars out of the partnership. There are investors here who will never recover their principal because there simply isn't enough in the distribution amount recovered by the receiver to make that happen. And that was the basis for cases like Tremont and cases like the Second Circuit decision in the Madoff case itself, where the courts talked about going with a last statement method based on, which is what the appellants here advocate, based on statements that were permeated with the Madoff fraud, based on fake profits, non-existent security trades, and a fund that won't allow the recovery by all investors of their principal. They called it, those cases called it absurd, and said that if the court permitted the last statement method, that would be furthering the fraud. And we suggest here, and this is similar to the Lipper case, where the court also said, just in conjunction with the limited partnership agreement, this court, in a unanimous decision, said that the general partner was absolutely correct to determine the capital accounts based on accurate, economically relevant information and not fictitious fraud, which was also the case there. I know I don't have much time, and we'll try to just sum up a bit. The cases that the appellants cite with respect to limited partnership agreements really say no more than a limited partnership agreement will control over the limited partnership law of New York. There's not much more to them than that. They come in situations where there are contractual dissolutions or contractual disagreements with third parties, not equity receiverships. That is crucial here to keep in mind, that the New York Supreme Court put this equity receivership in place, and the New York court had the ability to order an equitable distribution based on its finding that the receivers laying out of all of the various calculations, the methodology, and the impact of that methodology on the investors was fair and reasonable.
Thank you. All right,
Thank
Mr.
you, Your
Orloff,
Honors.
you have 2 minutes.
Thank you. Thank you. I'd want to address the agreement and the statement by one of your honors that that the receiver was the managing partner. In effect, he was. And if the managing partner were to do what this receiver tried to do, he would have violated the agreement. Section 1101 of the Limited Partnership Agreement says that a partner's capital account, computed as per the agreement, cannot be reduced without the consent of that partner. And so the receiver, just because he was appointed by the court to liquidate
Counsel, this
his
is
trust,
cannot. Counsel, this is Judge Owen. Yeah,
Yes.
That's correct what you just stated about the limited partnership, but there's also Article 8 of the Limited Partnership Agreement when it talks about dissolution and winding up of the affairs of this limited partnership, right? And that's that's the factual scenario that we're dealing with, the winding up of the affairs. It's not capital accounts that you're talking about, it's something different. So that's
But it is the capital account, Your Honor, because what the receiver did was he retroactively changed the capital accounts. For the first 10 years of this receivership, even though there wasn't much being done, K-1s were issued every year in accordance with the capital account statements that existed before and right after the Madoff implosion. So the receiver went down the line of following that until almost 10 years later, when he decided to try to put this other mechanism into place. I just want to add, because I know my time's limited, Your Honors, I want to make sure Your Honors focus on the Beacon case and the Greenspun case, which are 2 cases that we cited, which dealt with this very issue involving an entity in which funds were invested in Madoff, and where the court said in both of those cases that the last statement method, the capital account term, should be followed. I also want to point out to Your Honor that in the Lipper case, which is the case that they are most relying on, there was specific language in the partnership agreement that gave the general partner the right to change the capital account numbers. We don't have that here, and this is unlike Lipper. The fact that the receiver was acting under the Martin Act does not change his obligation to honor the agreement. And indeed, one of the cases that just came down in the second department last year that we cited in our reply brief, the AJG Parkview case, specifically involved a receiver, and the court said that the receiver did not have the right to alter the partnership agreement, and he had to honor the partnership agreement whether or not he considered that that was fair to the partners. This case involves the relationship between and among these partners themselves, and not fraud on the part of anybody in Ascot. Thank you.
Thank you. Mr. Ossis?
Thank you, Your Honor. No one disputes that that when the receiver took control of the partnership, he was obligated to honor the commitments, the contracts that the partnership had entered into with third parties. No one suggests that he could have just walked away from those commitments and contracts. But what the receiver is now saying is that he can somehow walk away from commitments and contracts he made to the limited partners themselves. And that's the point that we dispute and challenge. We say that in the absence of fraud in the formation of that limited partnership agreement, or at a minimum in the management of that partnership, he has no such authority. And for that reason, we say that the fact that the external fraud by Madoff had an impact on the Ascot partnership does not give the receiver authority to override the limited partnership agreement or the court sitting in equity to do the same thing. And on the point about about what the limited partnership agreement allows him to do in Articles 3, 8, and 11, we discussed that in our reply brief, and we would refer the court to our papers on that.
Thank you.
Thank you, Your Honor.
Thank you. Thank you all.
Thank you, Your Honors.
The next case is EPK Kid Smart against Lorette.
May it please the court, Your Honor, Hilda Piloto of Saul Ewing on behalf of the appellant, EPK Kids. Your Honor, we are here today as appellant seeks the reversal of the lower court's order granting a forum non-convenience dismissal because the trial court abused its discretion when it found that defendants satisfied their heavy burden of establishing that the FNC factors favored dismissal. In the alternative, appellant requests that this court remand this matter with instructions and allow jurisdictional discovery, as EPK has at a minimum made a sufficient start towards jurisdiction warranting discovery. Your Honor, what is interesting about this case is that the trial court, in reaching its conclusions, weighed evidence provided by appellant versus nothing. The record is devoid of any evidence submitted by defendants to carry their heavy burden. For example, the record is replete with evidence of defendants' repeated, deliberate use of New York banking accounts to carry out the scheme and fraud detailed in the complaint. In response to these detailed allegations contained in the record, in the complaint, and in the affidavit submitted, the defendants stood silent. The record reveals that the defendants only filed one substantive affidavit, the affidavit of defendant Gonzalez, found at record 168 and record 973. A review of that affidavit unequivocally establishes that it is silent as to any forum non-convenience elements. Instead, it just provides a series of documents related to an action in Venezuela, which is not where the court sent this matter. Mr. Larray provided no affidavit. Defendant Bridgewood, no affidavit. Thus, it's EPK's position that based upon the unrebutted evidence contained in the record, the trial court improperly weighed the FNC factors because it could not find, under any circumstances, that the defendants met their burden of establishing hardship, establishing availability of an alternative forum. And absent those findings or that weighing, the trial court's order is improper as to forum non-convenience because it is devoid of any actual weighing of the elements for forum non. Similarly, apart from not disputing that the defendants are providing zero evidence that the defendants do not reside in New York, the defendants do not dispute that they conducted the mark-related business activity in New York. They do not deny the amount of bank accounts at over 20 times in 2015 and 16. The defendants or others at their instruction requested that appellant transfer funds, which are critical to the allegations of fraud in the complaint. This complaint alleges claims for fraud, conspiracy, and tortious interference, all with a nexus to New York. Those facts were ignored by the trial court, and as such, it's our position that the court ignored that it was the defendant's burden to decide, to prove that it was actually, that this case was actually subject to forum non. Additionally, the trial court placed the burden of availability of an alternate forum on the plaintiff, and that is simply not the law. The defendants carry the burden as to each and every element of the factors.
Okay, thank you.
You're welcome, Your Honor.
Right, let's hear from the other side.
Good afternoon, Your Honors. Gail Dick from Cohen and Gresser, appearing on behalf of the respondents. The motion court did not abuse its discretion in dismissing this action for forum nonconvenience. This is a fundamentally foreign litigation with no real connection to New York. Instead, based solely on the pleadings and the records submitted by the plaintiff, the case is clearly rooted in Colombia in virtually every way, and it should be litigated there, if anywhere. In brief, the crucial events giving rise to the claims occurred in Colombia. Colombia law governs this cause of action. Appellant is a resident of Colombia. The dispute relates to appellant's business, which is the sale in Colombia of children's clothing. Excuse me.
And Mr. Gale, because your adversary said no affidavits were provided, no information was provided to support that position. Your argument, as I understand it, is that these were the facts that were alleged in the pleadings. Is that correct?
That is correct.
This could be gleaned from the pleadings.
From the pleadings and from other documents, affidavits and attachments submitted by the plaintiff.
Okay.
Among other things, it's clear simply by virtue of the fact that there are ongoing proceedings in Colombia and that plaintiff has conducted his business in Colombia for many years, that Colombia provides an adequate alternative forum. There's no real question that tribunals and courts in Colombia are perfectly adequate to handle this dispute. The relevant legal standard requires looking at the totality of factors, not one of which is dispositive. And Justice Sherwood properly considered all of the factors. And because most of them, or all of them, clearly favor dismissal, the trial court did not abuse its discretion in granting the motion. In fact, appellant's briefs, especially their reply brief, essentially concedes, either openly or effectively, that nearly all of the forum nonconvenience factors weigh in favor of litigation in Colombia rather than in New York. Appellant does not really dispute that Colombian law governs their claim. Instead, they really contest just one of several reasons that this is true. Appellant does not really dispute that at least some evidence and witnesses are located in Colombia, and makes no effort to argue that any substantial evidence or key witnesses are located in New York. Obviously, it's undisputed that appellant is a resident of Colombia.
Mr. Gale, I'm sorry, this is Justice Shulman.
Yes.
Basically, the banks weren't used to further the fraud. The banks were really repositories of the funds, true?
That is exactly right, yes. Which distinguishes this case from all of the cases regarding the use of bank accounts cited by appellants, both as to forum nonconvenience and as to jurisdiction. In those instances, the use of bank accounts was itself either the fraud or the other wrongdoing. Funding terrorism, for example, shifting assets so that they were not available to the plaintiff, that kind of thing. It's also worth noting that there are three claims being asserted here. There's been no assertion ever that the tortious interference claim has any attachment to New York whatsoever. All of those events occurred in Colombia. The injury was sustained, whatever that injury was sustained in Colombia. No funds were transferred to New York in relation to that. The fraud claim, it's essentially undisputed that all elements of the fraud were accomplished in Colombia. It's unclear from anything in the record where the misrepresentations were made. There was one meeting at which the issue of these allegedly inflated invoices was discussed. That was in Bogota in 2016. But the reliance on those misrepresentations took place in Colombia, and the payments were made from Colombia. It's crucial also to note that that in connection with the inflated invoices, which related to the purchase of merchandise, those payments were made by the plaintiff to Hong Kong, not to New York. At that point, once the injury was incurred, the fraud was complete. Again, as you pointed out, Justice, the repository of those funds is not relevant to the fraud, nor do the
Can I ask you to
allegations.
wrap up your argument because you've exceeded your time?
Oh, I apologize.
I don't need an apology. Just wrap up.
It's our position that the pleadings and the records submitted by appellant clearly support the grant of forum nonconvenience dismissal here. and we urge this court to affirm. Thank you.
Thank you. Thank you both. Okay, People versus Stacy Jackson. Mr. Seawald, you may proceed.
Good afternoon, Your Honor, and may it please the court. My name is Amelia King-Musa, and I represent appellant Stacy Jackson. I'll be focusing on the issue of the 911.
Sorry.
It's okay.
Yeah.
My
list says you backwards, but we can roll with the punches. Go ahead.
I'll be focusing on the issue of the 911 call. The 911 call was improperly admitted. It is not a present sense impression, nor an excited utterance. The call occurred well after the incident ended, and the complainant, Brock, had time to reflect.
Do we know how much time, I didn't see in the record, how much time do you claim elapsed between the altercation and when the defendant then ran away and made the 911 call?
Sure, just to clarify, it was the complainant who made the 911 call, not the defendant.
Correct, this is right. I'm all mixed up today. All right, yes, but you understand the period of time that I'm trying to figure out.
Yes, so according to security footage that was admitted in People's Exhibit 1, Mr. Jackson left his apartment building at 8:49 and some seconds. The incident takes place immediately thereafter on that same block, and then the call is placed at 8:55. Now, just two notes about that. First, the first 40 seconds of the 911 call are actually silent. The 911 operator asks Brock multiple times, "Are you there? Hello, hello," and Brock does not respond. So that indicates that there is some additional time for reflection. And second,
does the nature of the conversation and the call at all indicate that during the phone call, the complainant still thought that he was in danger?
Sure. So Brock says during the call, the guy is still here and, quote, he's coming back around. But when the 911 operator asks for a description of Mr. Jackson, Brock gets it wrong. He doesn't say, he says completely different clothing than what Jackson is actually wearing.
So even accepting that, though, why does that go to the admissibility of the evidence rather than just the weight?
So it goes to the admissibility because it really cuts against any argument that this call is reliable. And the foundation of both of these hearsay exceptions is that the call is reliable because the caller is under such influence of this event that they cannot fabricate. And yet right here in the contents of the call itself, we have indications, one, that the caller can reflect and fabricate, and two, that they are doing so at that moment. Because if they were looking at Mr. Jackson himself, they would have been able to say this is what he's wearing. Additionally,
or maybe it reflects the fact that he was so stressed out that an accurate description of the color of his clothes wasn't uppermost in his mind. So I'm not sure how that really, as a matter of law, defines fabrication or inability or the ability to reflect and fabricate. I'm just not sure it cuts that way, one way or the other.
Additionally, Your Honor, if we look at the timestamps of this 911 call, as I said, it was stipulated in the record that this call happened at 8:55 p.m. The call goes on for some minutes, and I believe Brock gives that description of Mr. Jackson about 2 to 3 minutes into the call. And yet security footage of the apartment building lobby shows that Mr. Jackson has already returned to the lobby right around that exact same time. So he's not coming back at Brock. So it's additional proof that there was not, this isn't, Brock isn't giving a contemporaneous narrative of what he's seeing here. And I would just like to add, briefly turning to preservation. This is clearly preserved on, trial transcripts, pages 87 and 88.
You actually address whether it's harmless error, even if you're right about its admissibility. Why is this not harmless error in this case?
Absolutely, Your Honor. So there was not overwhelming evidence of guilt. As I argue in point 1 of my brief, the verdict was actually against the weight of the evidence. This case really hinged on the existence and use of the box cutter. The only evidence of the box cutter in this case comes from Brock, his trial testimony, and the 911 call. The box cutter was never recovered, and no one else has even seen the box cutter. Now, not only does the prosecution rely on this 911 call during summation, but just the 911 call being admitted in itself, Brock's testimony, as I explain in point 1 of my brief, is inconsistent in many ways. And the jury may well have had doubts, but turned to the 911 call, where they hear this same statement about a blade or a box cutter, and therefore credited his testimony.
One question, though, about that. Did the medical evidence that seemed to say that the injury that the complainant suffered was consistent with a cut from a box cutter, is that corroboration of the existence of a box cutter?
I believe that the medical evidence did say it could be a box cutter, but medical evidence cannot say absolutely that this was a box cutter versus a different type of sharp object.
But the only other sharp object here was a piece of wood, and they don't make the same kind of injury.
There was the piece of wood, Your Honor, and it did have staples sticking out of it, which I do not believe is contested. I think the officer's testimony on that is that there were staples sticking out of this piece of wood. So it was really the repetition of this statement during an unreliable 911 call that was brought in to bolster an incredible testimony that gave the jury an exaggerated view of the probative evidence or the probative force of this statement and of the party's case in general. And if there are no further questions, I'll reserve the rest of my time for rebuttal. Thank you.
You only have rebuttal time. That's all that's left, but that's okay. I've given everybody extra time. And, any questions, colleagues? All right, now we'll hear from Mr. Seawald. Go ahead.
Good afternoon. May it please the court, Andrew Seawald for the people. Your Honors, I would submit that this 911 call was a quintessential excited utterance. The victim placed the call within a minute or two of having been slashed by a razor blade or box cutter. He was slashed deeply enough that he had an exposed tendon in his arm. He was bleeding seriously enough that he was dripping blood on the sidewalk. And it was in that frame of mind that he made this 911 call. He described having been just cut with a blade, and he said that the person who cut him was still here, and all of these circumstances suggest that he was still under the influence of what was obviously a startling event, and he made the call a very short time after that event occurred. And given all of those circumstances, the court was correct in admitting the 911 call as an excited utterance. And if there was any question about the reliability of the narrative that the victim gave during the 911 call, all of those questions were properly put before the jury. Any inconsistencies in the descriptions by the victim were put before the jury. He was subject to cross-examination, and there was also lots of other evidence that he was indeed cut by a box cutter, including, as Your Honor, Justice Gish pointed out, the medical testimony that his injury was consistent with the box cutter, which was obvious enough from the medical records and from the injury, the nature of the injury itself, a deep straight line cut to his forearm. So under all of these circumstances, the court was correct. If there was any possibility that the court was incorrect in admitting this as an excited utterance, that error was certainly harmless given all of the evidence in this case. And if there are no other questions from the court, I'll rely on my brief and ask the court to affirm. Thank you very much.
Thank you. Any questions, colleagues? All right, Ms. King, Musva, we'll hear from you in rebuttal.
Sure, Your Honor. I would just like to say very quickly, the 911 call is not an excited utterance. It's also not a present sense impression, but it's not an excited utterance because Brock is clearly not under the influence of the event. He isn't cowering from Mr. Jackson. Both men have left the scene. Brock has walked a block away at this point. Mr. Jackson is back in his apartment building. Brock has had time to reflect, and as I mentioned, judging from the contents of the call, he really has. And legal scholars, including at least one member of the Court of Appeals, have begun questioning the excited utterance exception because advancements in psychology and neuroscience really demonstrate that people can create falsehoods immediately. And I think that this case is a good example of that and why temporal proximity alone cannot make a statement reliable. And before I go, I would just like to point out, I submitted to the court supplemental authority just last week. This court found that a 911 call was improperly admitted as a present sense impression under very, very similar circumstances. The caller was a complainant who walked a block away.
You're talking about the Merritt case.
Yes, I am, Your Honor.
You have it.
Okay.
Have it.
And in that case, it was found harmless because the box cutter, there was outside evidence of the box cutter itself was found, and that is simply not the case here. The box cutter was never seen or found by anyone else. So with that, we ask that this court reverse and order a new trial. Thank you.
Thank you. Thank you both. All right, the next case is Bonnet versus Rose Associates.
Good afternoon, Your Honors. This is Barry Scheinbaum. It's a pleasure to be before you to speak on behalf of Appellant Aggressive Shade Glass and Awning. The lower court found that Aggressive did not meet their burden by establishing evidence through a witness with personal knowledge of the inspection that they performed on March 15, 2017.
This is Judge Kern. Even if we consider the custom and practice of the person who went out to inspect the windows, why aren't there still unresolved issues as to instrument of harm was launched as a result of the inspection, since the evidence that we have before us is before it went open and after the inspection, it closed on his fingers, which is a different condition that it initially existed.
Thank you, Judge Kern. That's an excellent question, and I'm happy to respond in showing that I believe that Aggressive has proven through sufficient evidence that after they did the inspection on March 15th, they made sure, Mr. Tillett testified that he made sure that the window was fully aligned so that it could close. Now, we know that's true too, because when the plaintiff testified, he said that after Aggressive inspected the window. When he looked at the window, he didn't see anything of that window change. It was properly aligned. It was closed, and in the 3 weeks between the time when the inspection was done and the accident happened, he had never heard the window rattle. He had never seen it shake.
That no one used the window in the interim, that he came in, he did his inspection, and the next time the window was actually used was when the plaintiff got injured.
Yes, Your Honor.
That raised a factual issue that it was something about the inspection that could have made the window more dangerous than it was before the inspection, since no one else touched the window in the interim.
Well, actually, that hasn't been established, but I know that it's my burden. But even if the court recognizes that that was the first, even if the court were to say that that was the first time it was opened, that's where the Court of Appeals and all of the prodigy in terms of Church and Santos all come into play. Aggressive had to inspect that window. They had, in order to be able to fix it and determine what the problem was, they had to inspect it. So by inspecting it, it had already been determined that the window was not safe and operating properly. The building handyman told the plaintiff.
Changed, though, counsel, what changed, allegedly, is that the malfunction before was that it couldn't be opened. The malfunction never had been that it would close on someone and injure them. So the particular malfunction that caused the injury was never reported before.
Actually, that's not true, Your Honor. The testimony from the building handyman, Ellis Constantine, who inspected the window 5 days before Aggressive did, said that he believed that the springs and balances were not working properly, and that was why they needed to call Aggressive in. He actually said that he lubricated the window in 2 spots before Aggressive touched it so that he could try to see why the window was not opening properly. It wasn't that the window wasn't opening, it was that the window was hard to open. So he and the plaintiff themselves used WD-40 to lubricate the building in 2 different areas. Then Constantine determined that the window needed to be repaired by their specialist because the springs and the balances were broken. That was the same thing that Aggressive determined when they inspected the window. So if you look at the evidence, it's actually pretty clear that prior to Aggressive ever touching the window, that the handyman who had been with the building complex for over 10 years had already made the same determination we did. And he actually, Constantine testified that he told the family, Bonnet and his wife, not to, definitely his wife. It's unclear whether or not Bonnet was there, but instructed them not to use it. And he wanted to put a sign up on the window telling them not to use it. Now, if this court were to find that because Aggressive inspected the window and then the top portion fell down, that would mean that would actually bring this outside of the Court of Appeals, which said that before you fulfill an obligation, you should not be responsible for any injury that arises out of that. So that comes from Church, and that was basically where they were installing the guardrails, and they had not finished installing the guardrails where the car had overturned and the person got injured. And the Court of Appeals specifically said that when you don't take on the obligation to fulfill your duty, then you're not liable. And that's the same thing with Aggressive. Aggressive did their inspection. They made sure that they left the window in a safe condition that would not harm Mr. Bonnet. Aggressive is not responsible to put up the a sign on the window, and it's clear through the documentation that was provided by both the building and Aggressive that they told the building what needed to be done, and they told them that they needed to order parts for the window before the window could be operated. The building themselves took it upon themselves not to put up a sign on the window. Furthermore, when the plaintiff then inquired from the building 8 days after Aggressive was there, whether or not there was a problem with the window or whether he could use it, the building didn't respond to that. That is so if the building had fulfilled their obligation by putting up a sign on the window and or responding to the plaintiff's email about the condition of the window, this accident would never have happened.
Counsel, this is Judge Owen. But
Hi.
doesn't that scenario that you just put forth, unless I missed something, doesn't it sound like comparative fault then?
No, Your Honor, because the thing is that proximate cause says we're not the
No,
proximate.
it's comparative fault of the defendants who is more responsible. You're either 30%, 10%, or the other side, the building owner not putting up the sign, they're 90%, I mean, because unless I'm mistaken, the fact said that between the time of your inspection to the time of injury, nobody touched that window.
It's not clear whether or not somebody did, but even barring somebody else being there, because it's my burden to prove, and I wasn't able to show anybody else in the apartment. But even it's not a matter of fault here, because I asked this court then, how is a
Well, wait a
third-party
minute.
contract?
No. When you say it's not a matter of fault, you're shifting the fault on the owner, saying that the owner should have put up a sign.
No, what I was saying, I said that was an intervening, superseding cause that took a break in the proximate causation, and therefore Aggressive shouldn't be responsible for it.
Failure to warn is a superseding cause?
No.
What I am saying,
I don't think that's right, but honestly, unless my colleagues have any further questions, I'd like to hear from your adversaries at this point. Any questions for Ms. Scheinbaum? Okay, Ms. Sonnenborn.
Thank you, Your Honor. May it please the court, my name is Marcy Sonnenborn on behalf of the building owner. So I agree with what all the other justices have expressed, which is what the lower court expressed, and that is that questions of fact abound here. I think that when I first read the briefs of that were before the lower court, I said to myself, what happened? Why did this upper window fall on the plaintiff on the day of the accident? He had come in with his wife initially and found the window difficult to open. They called a handyman in the building, Constantine. He did not know what was wrong with the window. What he knew was that he had to call Aggressive, who was the building's expert in repairing windows. And that's exactly what the building did. The expert came in, the technician came in, he came in with a helper, and we don't know what happened in the room that day. All we know is nobody else touched the window, and the next time that the plaintiff came in and opened the window, it fell on his finger. So as I said, I read these briefs and I said, what happened? The burden is on Aggressive, who's asking for summary judgment to prove that their technician did not conduct any act which could have exacerbated or caused this accident. They didn't do that.
This is Judge Owen. According to what I heard from the argument from the appellant, she's trying to shift. The argument is that your client should have put a sign up because according to the technician, he told somebody of your client that, oh, don't go near the window, don't use the window, and that was it. And that now it's on you that you didn't put a sign up. That sounds more like comparative fault. I don't think that sounds like it's all your fault.
Well, I agree with
If
you,
we were
Your
going,
Honor.
if you were to agree with that.
I agree with that. I mean, this is a question of common law indemnification. The purpose of common law indemnification is equitable distribution to between the parties that may have been responsible. This is a case of multiple defendants. There may or may not have been fault on the part of the owner. There may or may not have been fault on the part of aggressive and on the part of the plaintiff. So we cited cases which were not distinguished by aggressive, in which an owner is entitled to maintain a common law indemnification cause of action against a contractor who may have had some part in causing this accident. Aggressive could have submitted.
That goes to your argument. That's a trial of fact. This is a factual issue here. This is all factual issues that's got to be resolved at trial.
Correct. These are factual issues. Now, as an example, if aggressive, who has the burden, aggressive's counsel readily admits that it's her burden to disprove negligence, why didn't she put in the affidavit of an expert explaining why did this window fall? What exactly happened? What would cause this window to fall so suddenly? We don't know the answer to that. That is the very basic question, is why did the window fall and who caused the window to fall? And without proving that, aggressive has not met its burden. Another point I wanted to make is that aggressive relies upon the Court of Appeals case Church. That's a case of incomplete performance. This is not a case of incomplete performance. We are not arguing incomplete performance. We are arguing that a question of fact exists as to whether or not the aggressive technician caused or created the condition which caused the plaintiff's accident. If the court doesn't have any further questions, I will rest on my brief. Thank you.
Mr. Bernstein?
Good afternoon, Your Honors. I will be fairly brief. This case comes down to questions of fact, assuming that the appellant even met their burden in shifting to the respondents to raise tribal issues of fact. Aggressive does not dispute anywhere that no one touched the window after the inspection until the plaintiff's accident. Consequently, aggressive offers absolutely no evidence that it did not negligently create or exacerbate the condition which caused the accident, which fails to prove by someone with personal knowledge who they produced, who essentially stated that he did not recall anything that was done, meaning that it did not launch or force an instrument of harm. In the appellant's brief, they incorrectly try and argue that it's the respondent's burden to on a motion for summary judgment to show that the appellant did nothing wrong. To the contrary, as the appellant has already stated, it's the appellant's burden to show that they're entitled to it, which I do not believe that was done by any means in this situation. And also, I'd just like to point out a few things as well. There's a few arguments in the appellant's brief that were never even brought up in the lower court, which was mentioned briefly by the appellant, including proximate cause, which was brought up. That was never brought up in the lower court. It was never argued. It was never put in their papers. And there's also something in their brief regarding a failure to state a cause of action. That was also never brought up in the lower court. It was never argued. There was nothing in the papers about that. And if the court has no further questions, I will rely on my papers, which clearly show that the burden was never shifted. And even if it was shifted, there are numerous tribal issues of fact which should be resolved by a jury.
Any questions, colleagues? Ms. Schinbaum, you have 2 minutes.
Yeah, there was something that was said by the building's attorney where they said that it's very clear by the record that their handyman had determined that the springs and balances were not working properly, and that was the reason that they brought aggressive in. And aggressive does believe that they've met their burden both in producing somebody that had personal knowledge of the inspection that they did based on their 10 years of inspecting the windows in this building. But the other thing is that it's Aggressive's position that we did not leave the window in an unsafe manner where when after the inspection was done. And with respect to inspecting the window, by the time that Aggressive even learned about this accident, the window had already been done. Plaintiffs, Mr. Bonnet, as well as the building, both had two inspections of the window by experts before this lawsuit was brought, and neither one of them was able to say what they believed Aggressive did wrong. In fact, the testimony was by the building that they didn't believe that Aggressive had done anything wrong. And it's in inspecting the window, if a third-party contractor doesn't have the liberty to be able to determine what's wrong and do the inspection the way that it needs to ensure that once the job is fulfilled, that it would be in a safe position, then that would ultimately end any protections for third-party contractors. And Aggressive it is my position in arguing for Aggressive that this was an unfulfilled contract because they had not started to do the repairs yet. And based on the fact that they didn't do engage in any repairs because they needed to wait for the parts to do so, then the best that they could do would be to leave the window in a safe position and advise the building what needed to be done to ensure that an accident like this didn't happen. Thank you for your time.
Thank you.
Go ahead.
Thank you all.
Rest of my papers.
Okay.
Thank you.
All right, Ziegelstein versus the Roth Law Firm.
Good afternoon, Tammy Harris for the appellant. Can you hear me okay?
We can.
The major error that was in the lower court in this case was Judge Perry's failure to look at the alternative element for proximate causation in a legal malpractice case. And what Judge Perry did was he basically asserted that if plaintiff couldn't meet her case within a case requirement, then therefore her case was doomed. And that wasn't accurate. The alternative element set forth by the New York Court of Appeals under the case of Dax versus Shane clearly says that if a plaintiff alleges that an attorney's negligence causes ascertainable damages, that is sufficient for her case to move forward. And this,
Ms. Harris, isn't that the standard that really applies if it's a transactional malpractice, and that the standard that Judge Perry, and I'm not agreeing with you that he didn't look at the standard or the application of res judicata to both standards, but isn't this causation standard for a litigation malpractice the case within a case? And the alternative, what you're talking about, at least in this case, is really just a consequential damages issue. It's not a causation issue.
well, actually, Your Honor, I respectfully wouldn't agree with that. I think that one of the—
Tell me why.
Sure. I think that one of the cases that highlights that is the Bora Goldstein case, where the lawyer commenced the action with a defective lien, for example, which then compelled a bunch of challenges by the defendants that the client had to pay for. And even though the client couldn't win the ultimate case, the court said that's irrelevant. If the lawyer had not engaged in these negligent acts, there wouldn't have been these challenges, such as in Ms. Ziegelstein's case, with all the motions to dismiss that followed, and that the lawyer caused these ascertainable damages. Similarly, in negligent advice cases, which actually is this case, if you look at record 490, it's very telling. Richard Roth actually, in his own words, tells the plaintiff, once her case is dismissed by Judge Singh, he says, don't worry about the statute of limitations. He says it's told, which we all know it's not really told for attorney negligence. And it wasn't told for Roth during his 15-month parade of horribles. Yet in that record, on page 490, he says, let's sue every single defendant again. After the dismissal, let's use the same complaint and the same summons, and we have a meritorious case. I'll put in all the evidence that I didn't put in the beginning. He admits on record 490 his original complaint was deficient and says he's going to fix things. And he's basically inducing this plaintiff through negligent advice. And despite admitting to the appellate division in his submissions before this court that he knew these claims were stale, he's telling her, give me more money and I'll bring action number 2. And he does bring action number 2, which gets removed to federal court on diversity grounds and gets dismissed. And to be crystal clear, because Roth is very good at distracting from the main issues in his papers, this is not the same federal case that Cardillo represented her on 3 years after the fact. So Roth caused 2 cases to get dismissed in representing Ms. Segelstein. And he lied to her, telling her a statute of limitations was told to induce more money. This is a classic case under even the First Department's Willow case, where a lawyer gives negligent advice to induce a client to pursue a case that, if we're going to take Roth's assertions as true, he believed had no merit. And that's exactly what happened in Willow, which I believe was a specific performance case where the lawyer induced the client to bring this specific performance action, which had no possibility of winning, caused the client to spend exorbitant sums of money. And the First Department, only a few months ago, said you can't do that. The client doesn't have to prove case within a case. When there's negligent advice, it suffices if there's ascertainable damages. And what's critical, Your Honor, in this case is that it's Roth's burden of proof to utterly refute plaintiff's allegations as to this second alternative element, yet he doesn't even submit an affidavit. This is literally a motion with 0 admissible proof. He does not refute. He took $185,000 to literally file 3 things for this plaintiff. He filed a defective complaint that didn't even allege a specific date that money was diverted, where he ignored hundreds of pages of evidence she gave him, of checks, explanation of benefits, patient letters, including a patient letter from patient FW in February.
Well, that wouldn't have helped here, honestly, because that is the problem with the case within the case. You know, so that's not it. But the additional expenses may have been other stuff. What else?
Okay. Well, I would just respectfully say that I know that it was raised with the case within a case issue that Mr. Roth said we were collaterally estopped. It's never been determined by a court whether plaintiff's case would have been deemed to have merit had Roth in 2014 included the evidence that he excluded.
Well, why was that different than the federal case?
Because the federal case was decided in 2017, and Mr. Cardillo entered the case, that specific case, years after, when claims that were admittedly on the cusp of the statute of limitation that Roth could have saved with an amended pleading and would have related back to 2014.
Yeah, but the federal case didn't just say, gee, statute of limitation. They said no merit substantively. So what? I mean, that seems to be at the core of the lack of causation of the case within a case. Had he filed the complaint that you think he should have filed in the state court, that it substantively had no merit, leaving aside the statute of limitations issue.
Well, just to be clear, that we never said that I've never said that the complaint lawyer number 2 filed was the proper complaint. Those words were used by Roth. There were clearly errors 3 years later in the complaint that was filed by him. But to go back to the main point, the alternative element does not meet his burden of proof. And although the judge cites Dax v. Shane, and he does set forth that the law requires this alternative element, if you look beyond that, the factual recitation completely ignores it. As to the issue of whether the breach of fiduciary duty and breach of contract were duplicative, I would like to touch upon that. The breach of fiduciary duty claim is based on plaintiff's clear allegations of a conflict of interest, that Roth basically lied to her.
You know, that you're way over your time, but we have your briefs on that. And I think that's more of a collateral issue. Your main issue is the alternative basis for proving causation. And let's hear from Mr. Roth.
Thank you, Your Honors. I've been before some of these judges personally, never in my own case, so it's somewhat distressing to be here, but notwithstanding, I think the judge...
No, I wouldn't have bothered to use 10 seconds of your argument time for that, but so
I'm
be
sorry. Your Honor,
right?
I think Judge Gish hit the nail on the head.
I don't think I did, honestly, because I want you to explain to me why they don't actually allege the alternative. the alternative here, which the cases say is ascertainable damages proves causation. Why don't we get to that here?
Sure, Judge, because even the alternative, you could take any of the cases that that the appellant relies on. In the Borer case, there was not only negligence, but it proximately caused injuries. In the Willow case, there was negligence that proximately caused injuries. And
What do you mean by that? I don't know. What do you mean by that?
What I mean by that is that
that's what we're trying to get at. What does that mean?
I'm sorry, Your Honor, I didn't mean to interrupt you. What it means is that in every case cited by this court and the Court of Appeals, you have to show negligence, and you have to then show a case within the case. The negligence resulted and it had caused a different result. And Your Honor, to your question.
But what does it mean in the Rudolph case where the court states the standard for causation in the disjunctive? It says a case within a case or ascertainable damages.
Right, and in the Rudolph case, it was shown there were two trials, and there was a difference in the second trial. In the Rudolph case, the jury charge was wrong. There was negligence by the lawyer. In the second case, there was a different result.
There were definitely mistakes made. Maybe the underlying case was terrible, but there were mistakes made, and if they caused her to expend money, that's not enough.
Your Honor, the answer is no, it's not. You're not entitled to reimbursement of the fees you paid. You're entitled to the difference between what you had and what you would have had there not been negligence. But the problem with the argument by the appellant is that not only did Judge Forrest say that this case is dismissible, it's frivolous, don't come back to me again, but Judge Singh in the underlying case, Judge Singh, when this court the first department brought it back to Judge Singh did an analysis. He said, was there a good cause for an extension to serve the summons? And he said no, but he went further. He said, quote, he said, in the interest of justice, to grant the extension because the underlying statute of limitations for the claim against the practices and other defendants had already expired on the date of the complaint was improper. Judge Singh, in this case, in the prior case, went on to say that they were time barred and they were unmeritorious. So when counsel says to you, Your Honor, it's different because the federal court judge said that it was brought later. Judge Singh's decision was on June 9, 2017. Judge Forrest's decision was 4 months later, but to Judge Singh's decision on whether or not he would grant good cause to extend the summons, he said, I'm not, but it doesn't make a difference because there's no merit to the case. It's all been extended behind the statute of limitations in this case. And Your Honor, there's no better proof that there's no merit and it's beyond the statute of limitations than two judges, not one, well, now three. But Judge Forrest in federal court and Judge Singh in state court said it would not have made a difference. And I do believe that notwithstanding counsel's argument, you do have to prove that the negligence would have made a difference. And that's where I think it comes out. In addition to that, Your Honor, the collateral estoppel argument cannot be refuted by the appellant. The appellant, Judge Perry below said that the plaintiff is collaterally estopped because they've now tried 3 times to argue the same thing. In fact, if they went back to federal court, they would have been sanctioned. So, Your Honor, the argument collateral estoppel is a very independently strong basis upon which to deny the appeal. But more importantly, Your Honor, Judge Forrest, the complaint in the Judge Forrest litigation was practically identical to the complaint that was brought by my firm. So how is there negligence by the Roth Law Firm when the next lawyers on their own representing their client brought the identical complaint? In fact, they added 10 different insurance companies. So Your Honor, I think I'm almost out of time, but the answer is very simple. That there is still some kind of but-for requirement. It hasn't been just abrogated. And as important as the collateral estoppel argument, this appellant had the right to argue it in federal court and not only lost, but told her she would be sanctioned. She argued it in state court in the underlying case, and Judge Singh said it's beyond the statute and it's meritless. Thank you, Your Honor.
Thank you. All right, Ms. Harris. 2
Thank you.
minutes.
Thank you, Judge. Even assuming, for argument's sake, which I don't agree with, that what Mr. Roth says is true, that we're collaterally stopped from arguing merit because of the federal decision and the Judge Singh decision. My response to that is, so what? It's completely irrelevant to the alternative argument, which is that Mr. Roth caused ascertainable damages in the amount of $185,000 to Ms. Zegelstein by charging her to not serve a summons, to fail to serve a complaint on time, to admittedly file a defective complaint, which he admits on 490 he knew was defective, charges her to do a defective cross motion that doesn't even include an amended pleading when he's seeking leave to amend.
But doesn't this really, does this really go to causation for malpractice? Or is it what you're saying, it's a fee dispute, that he didn't charge reasonable fees for the work that was done? That's what I'm really having trouble with that.
That's a good point. And with respect to causation, plaintiff has to show that he's a cause of injury. In this case, because of the alternative theory, the injury is the legal fee she paid to him. That's the ascertainable damages. Clearly, that's
how can that be? It's really what you're saying is that you shouldn't have had to pay these fees. They weren't reasonable because they were unnecessary.
He has an overbilling claim, whether his work was reasonable, she has an overbilling.
That doesn't make it malpractice. It just.
But it does, Your Honor.
Unreasonable fees.
It does. If you look at the reason that there was a dismissal in 2015, the sole reason Judge Singh dismissed this case in 2015 was Roth's failure to serve. The sole reason and interest of a good cause extension was denied in 2017 when the case was remanded on Roth's papers and Roth's papers alone, not Cardillo's.
But we're going around in circles, because here's the thing. If the action had no merit, then the fact that he wasn't given leave to serve it, so what? So what? If he couldn't, if it had absolutely no merit, even if it were timely served, even if the motion were granted. So all it means is that he shouldn't have charged for those services, if you're right.
Well, respectfully, the reason it was dismissed in 15 had nothing to do with merit. It had to do with Roth's failure to engage in the most elementary task of serving process. And if you read the case of Dax v. Shane, it says, but for the attorney's negligence, there wouldn't be ascertainable damages. So the attorney's conduct, or lack thereof in this case, failure to do what most lawyers would do by attaching an amended pleading or serving process, caused ascertainable damages. It doesn't have to be the only cause. It has to be a cause based on the Barnave case. There could be other causes.
All right, we understand your argument. Thank you. Thank you both.
Thank you, Your Honor. Your Honors.
Okay, on the Terzi cases, 27 West 72nd and 31 East 28th.
Yes, Your Honor. May it please the court, Andrea Caruso for the appellants in both cases. Good afternoon. I'm going to kind of put them together. I do know there are separate arguments at some point. The arguments I'll make first are the ones that are joint for both of them. The first being that the plaintiff failed to make a prima facie showing, which is elementary on a summary judgment motion. This was a 3213 motion, a summary judgment in lieu of complaint, which has even a slightly heightened burden because you're sidestepping the entire process. So here, Mr. Shah, who is the principal of the plaintiffs, both of them in this case, in these cases, is put in an affidavit to support the fact that there was a default here. And I know Your Honors are probably very well aware of the facts. There were prior foreclosure actions here that were dismissed.
So why isn't there a prima facie case? All you have to show for a prima facie case is a guarantee, is the existence of the guarantee and a failure to pay. Why wasn't that established prima facie in this case?
Because Mr. Shah lacked the actual knowledge to lay out the payment history, which the failure to lay out the payment history, which was the basis of their default here, is the entire essence of this case. For them to collect under the guarantee, they have to prove that there was non-payment or a default under the terms of the note and mortgage, which would entitle them to go after the guarantee. He doesn't state he has no business records contained within his motion. He doesn't state that he looked at any business records. He doesn't
to do that. Why can't he just state there was a guarantee and the guarantee wasn't paid? And then the other side can come back and say, yes, the guarantee was paid. We paid the guarantee. There's no dispute here. He has made the prima facie statement. There's a guarantee, it wasn't paid. No one's come back and said, yeah, we did make payment on the guarantee. So I don't understand why that is not sufficient.
Well, I do believe it's insufficient, but I'll move to the next point, which I think goes to that, which is that these were limited guarantees. And because of that, on the 3213 motion, you are limited to the four corners of the guarantee under which you are seeking to collect the money. The problem is here is that under these limited guarantees, there were conditions. One of them, which is in both of them, is that a DSCR condition was or wasn't satisfied. There's no evidence as to whether it was.
Isn't it the case in these type of cases that you're allowed to put in some evidence outside the four corners to show non-payment? Because you would never, or a condition, because you'd never be able to show a guarantee wasn't paid just from the four corners of the guarantee. There is some amount of evidence allowed in these cases to show that there was a default. And why wasn't the evidence in this case sufficient?
I agree with you.
Undisputed.
I agree with you, except that condition has nothing to do with payment. It has to do with whether or not there were tenants in the building at the time with leases in effect for a certain period of time.
Dispute about any of those issues? Has the other side come back and said that those conditions were not met? There was an issue with them in any way, shape, or form?
Well, there's a difference in the two cases potentially. One has a limitation of $1 million, one doesn't. So I think while there's been no evidence either way, it's not the defendant's burden to produce something that they don't make a prima facie showing that it hasn't happened. And that's the problem, forcing the burden onto the defendant when it's the plaintiff's responsibility to show and state that, and not just state, they have to show that this condition hasn't been met or any of the conditions under there. There's also a slew of case law in this department that when the limited guarantee is not, or the guarantee, this case, the limited guarantee is for payment and performance of obligations, that it takes it outside of a 3213 motion.
And what performance is there, counsel, other than the payment? What these guarantees, what performance is required other than payment of the guarantees?
Well, page 45 of the record on the 28th Street case, because they are slightly different, has the guaranteed obligations that fall within, at least on 28th Street. On 72nd Street, it's on record 53, which is, like I said, slightly different because of the $1 million mark, but in all substance, the same. But if the SCR condition is satisfied, there's no liability under the guarantees at all. The guarantee expires; it's completely gone. So while that may be something that wasn't a big issue, it's a big issue with respect to whether the guarantee is valid or not. And that's something that has been discussed by this department. And I'm not saying ultimately what would happen, but this was a 3213 motion. We weren't even given the opportunity to go through any of these. I'll move on unless your honors have more questions on that point. Specifically on 28th Street, the amount of interest that was charged. So the difference between the two was on 72nd Street, no default interest was charged yet. It was pushed off. On 28th Street, the Judge Borak awarded default interest. And the problem with the default interest is that there's no question that when a mortgage is accelerated, which it was here in 2017, the maturity date is accelerated. That's what an acceleration is. And your new maturity date becomes the date of the acceleration, and the natural maturity date, or the maturity date that's within the loan documents, is essentially a nullity during that time period. These cases were litigated for 2 years. And ultimately, in 2019, in both cases, Judge Bluth, because there were two separate foreclosure cases, Judge Bluth threw the cases out and said, lender, you messed up. You didn't give the 30-day cure period, and as such, your foreclosure is thrown out. So in 2019, that acceleration essentially was thrown out. But what was done here was the lender was rewarded for their bad behavior in 2017 and said, well, now you can collect your default interest back 2 years. And that shouldn't be permitted. For starters, the fact that the default didn't exist in 2017 is a big thing. The maturity date didn't come into effect until 2019. So if any date is relevant, it's 2019.
2017?
I'm sorry, I missed the beginning.
Was the maturity date of the note 2017?
Yes, there were two, one was in 2007, in 28th Street, because that's the only one, was 2017, August 10th. In 72nd Street, it was August 10th,
Right?
2018.
Okay, Counsel, that's when we're talking about though, right?
Yes.
Once you're making the argument that 24% is unfair, you said because maturity was in 2017, but wasn't in fact 2017 the maturity date of the note?
That is the natural maturity date, but at the time the natural maturity date in the terms of the loan existed, there was an acceleration in place. That date didn't exist. They couldn't pay off on that date because there was an acceleration which accelerated it to May 30th, 2017 at the commencement of their foreclosure action. That August 10th, 2017 on 28th Street was not a maturity on the date in which it happened, August 10th, 2017, because of the acceleration months earlier. And that's applicable on both cases. And what's interesting when you look at both cases is Judge Schechter kind of realizes that there's an issue here with the default judgment, and she doesn't grant default judgment. Not default judgment, default interest, I apologize. And Judge Borak does grant default interest, and yet they're identical cases for all intents and purposes. So at the time in which the maturity happened, there was no maturity default. It was only once the acceleration was thrown out in 2019 that those natural maturity dates became relevant again, and therefore rewarding the lender for the improper notice that was given that Judge Bluth determined is rewarding bad behavior, which shouldn't occur equitably or in any circumstance. So the default interest really should have not been granted on 28th Street. On 72nd Street, the limited guarantee is limited to $1 million. It says specifically it's of the first $1 million. It's not just $1 million, and that's on record page 53. And that is significant because there's no evidence in the record as to the payment history here and how much is owed as of the date those cases were brought. And the problem with that is without a payment history, there's no ability to determine the first $1 million. Taking Mr. Shaw's—
And I'm just going to ask you to wrap up your argument because you're way over your time.
And this is my last point because I'll rest on the rest of the points in the papers. Okay. Mr. Shaw's claim, even at taken at face value without any proof of it, says that of the first $1 million, only $813,370.11 remained owed based on what he claimed the principal to be at the time he brought that motion. So taking his claim, which I think is unsubstantiated at best, it still shouldn't have been $1 million judgment. It should have been at most $813,370.11. But these are questions of fact. These were summary judgment motions. The amount owed, especially when there's $1 million limitation, is a question of fact that should have been pushed. I'll rest on the remainder and respond on rebuttal.
Mr. Nutter, go ahead.
Thank you, Your Honor. May it please the court, John Nutter for the respondents in these cases. Your Honors, I'll address Ms. Caruso's points in order. With respect
Can you actually do it backwards? I'd like you to address that last point first, that on the 72nd Street note that Mr. Shaw said only $813,000 was owed, and yet the judgment exceeded it. Why?
Sure, Your Honor. That question can be resolved by simply reading the guarantee and the guaranteed obligations. What it states is that the guarantor will pay the first $1 million of any outstanding principal, not of the original principal. And as of the date the action was filed, the outstanding principal on the 72nd Street note was over $6.8 million. So the guarantor clearly had to guarantee payment of the $1 million. There was $6.8 million outstanding, and if
so when did it become 813? I'm just not following the math.
I'm sorry, I missed that question, Your Honor.
When did it become less than $1 million?
It didn't. Her argument is that essentially that the principal balance went down from 7 million to 6.8 million, 6.813 million, and therefore the guarantor should only be liable for $813,000 as opposed to 1
Oh, I
million.
see. Okay, it's like a first in, first that the monies that came in had to be applied to the first million first.
Correct.
And there's nothing in the note or the guarantee that say that.
For that argument to prevail, the guarantee would have to say that the guarantor is only responsible for the first 1 million of the original principal. That's the key word. That's outstanding.
Got it. I understand now. Thank you.
And I can keep going in reverse order if you would like, Your Honor.
However you want now. I'm glad you cleared that up for me.
Well, let's move to the question of default interest on the East 28th Street guarantee. This issue is determined and was properly determined on summary judgment by simply reviewing the note. Section 8 of the note provides unequivocally that upon maturity, interest is payable at the default rate. This is a very straightforward application of the note, and the guarantee, which in the 28th Street guarantee provided that the guarantor would repay the obligations and the loan in full. There's no 1 million limitation there. So clearly, the principal balance plus default interest from maturity was due and owing and was properly awarded. As to the issue of, the application of the foreclosure action, Your Honors, this guarantee contained a waiver of defenses. Those are all issues that were litigated in the foreclosure action, but are not relevant in any way to this action on the guarantee. Clearly, there was a waiver of defenses in the guarantee, and it's simply irrelevant. So default interest was properly awarded based on the plain language of the note and the guarantee. As to the issue of performance versus payment, the guarantees, clearly they guarantee payment, okay, absolutely and unconditionally guarantee payment, okay. There's no guarantee of a performance that's at issue here. Okay, there was an absolute and unconditional obligation to pay in the 72nd Street guarantee the first 1 million or the 1 million of outstanding principal, and then the payments of the amount in full on the East 28th Street guarantee. There's no condition precedent that was at issue. The obligation was absolute and unconditional until the borrower attained the DSCR conditions. So there was absolutely no condition precedent at issue. And with respect to the issue of performance, Your Honors decided a case recently, March 25th, 2021, which I just discovered, iPayment Inc. versus Silver, in which the court approved the use of CPLR 3213 to enforce a guarantee, which also had language guaranteeing both payment and performance, because what was that issue? The guarantee of payment. So the court there made a practical decision that 3213 was appropriate, and the same is true here. Finally, the issue of Mr. Shah's affidavit, and this wasn't raised before the trial court, and I don't believe it needs to be addressed here, but I will address it. The affidavit was clearly sufficient for purposes of 3213. As was stated previously, all that you need is to show the existence of the note and guarantee, the underlying debt, and the failure to perform. And all of that was uncontested, indisputable. Okay, and once execution and default are conceded, the case law from this department states that it's incumbent upon the defendant to come forward to show an issue of fact, and that was not done here. So Mr. Shah's affidavit clearly established all that it needed to, and nothing more needed to be stated. And again, it wasn't argued in the court below. So with that, I'm happy to rest on our brief or answer any questions.
Any questions, colleagues? Okay, Ms. Caruso, rebuttal, please.
Sure. With respect to the case he cited, he didn't give notice ahead of time, so I'm not able to comment on that, and I would respectfully ask that next time that be changed. But points raised on appeal which challenge the legal sufficiencies are reviewable by the court without being brought up below. So the argument that they weren't brought up is frankly irrelevant. Going back to the $1 million issue, when it was first portrayed by Mr. Nutter, he said the $1 million of outstanding principal. It says the first $1 million of outstanding principal of the loan. It doesn't say at the time of default. It doesn't say at the time in which this was signed, the outstanding principal was the full amount. There's no definition for outstanding principal, what's intended by that, what the intention was, but it clearly says first. So there's an implication that the first $1 million, the law has always been first in, first out. So if it's the first $1 million, it would be the first $1 million that was paid down, which he paid down by Mr. Shaw's own testimony, almost $200,000 of the principal before this happened. That needs to be taken into account. And that potentially just in and of itself, the language, whether that meant that it's the first $1 million paid or the first $1 million after, whatever that intention of that is, that's a question of fact. That's not to be decided because they believe that what it says means one thing. It doesn't say that. That's their interpretation, and therefore that's a question of fact. The performance of the DSCR condition is a condition that is what entitles them to any sort of relief under the guarantees. The guarantees wouldn't be in effect if the DSCR conditions were met. So that is a performance-based claim, which this court has said when there's performance-based claims as recently as 2020 in Punch Fashion, where that judgments were vacated on 3213 motions because the cases looked for not only the guarantee of payment, but performance. That's what this is. Additionally, with respect to the claim that we waived, the Court of Appeals in Walcott, which is cited in my papers, says that there can be no doubt that a guarantor, when sued alone by the creditor, can successfully resist by showing that the creditor on his part totally failed to perform his obligations to the principal. That's why the 2017 foreclosure actions are relevant here, because there was a failure. They didn't do what they need to do. And by failing to do what they didn't do, they forced a maturity default. And that's the real thing here. Their impropriety forced a maturity default.
Yeah, we understand. You're out of time. This is the same argument you made.
Yes, it is. That was
okay.
Thank you, Your Honors.
Thank you.
Have a great day.
You too. Thank you both. All right. DiGirolamo versus 160 Madison Avenue.
Good afternoon, Your Honors. May it please the court. Michael Kazores from the Law Office of James Toomey on behalf of the defendant appellant, Parkview Plumbing and Heating. There's three essential arguments to the appeal. The first one involves the negligence claims and the related claims under Labor Law 200 and the common law indemnity and contribution claims. We believe that the lower court committed error in not dismissing the negligence claims because it's undisputed that Parkview was not doing any work in the location of the accident in the week prior to the accident. Now, of course,
so this is Judge Owen, but their argument is that you put the holes there. You created the holes, or you created the penetrations in the floor. That's their argument.
Right. That's correct. We did, but they're essential to our work. They're essential to the project. That's certainly not negligence. That also goes towards the contractual indemnity argument, which I can address momentarily. But in terms of
excuse me, this is Judge Shulman. One of the issues is whether the penetrations, even though they're necessary for Parkview's work for plumbing, is inherently a dangerous condition. Is their mere existence make them dangerous, or if they are uncovered, they're dangerous?
Their mere existence is not a dangerous condition, aside, in terms of creating liability. There's plenty of dangerous conditions on construction sites. That doesn't mean that they're actionable. And I think the Krzyzanowski case decided pretty recently by the First Department spells that out, that if a condition, even though it might be dangerous, is supposed to be there as integral to the construction project, then it's non-actionable. I think it's important to note that in the time when Parkview was last on site and when the hole and the covering was inspected, both on the day of the accident and the day prior, the hole was noted to be safe and secure. There's been a lot of discussion in the briefs about, well, Parkview might have removed the covering to do some work on the hole. 2 points with respect to that. First, there's absolutely no evidence whatsoever that Parkview uncovered any of these holes. Parkview's witnesses testified that the only reason why the holes would need to be uncovered would be so Parkview could run its permanent pipes through the floor penetrations. Once that's done, you can't put a covering back on it. So there was no reason for Parkview to ever uncover these holes. There's no evidence, either in documents or oral testimony, that they did uncover these holes. Second, let's say, assuming for the sake of argument that they did uncover the holes, we have the sworn testimony from the site safety inspector and his records that show that after Parkview was last there, the hole was covered and safely secured. So how the hole got uncovered at the specific moment of the accident, it's really irrelevant to Parkview's motion and on this appeal. The simple fact is, we created the floor penetration. New York City Acoustics covered it. There's no evidence we ever uncovered it, but even if we did, after we were last there, they were inspected and found to be safe and secure. So that takes care of all the negligence arguments, including Labor Law 200, common law indemnity, and contribution.
Sir, did they,
Yes.
Was there any argument in opposition with respect to the Labor Law 241-6 claim?
No, there wasn't. We raised that issue on our original motion. Plaintiff, I think correctly, did not oppose it. The court below just didn't address it. And, we raised the issue again on appeal. And again, plaintiff, I believe correctly, did not challenge that argument. So
it's essentially abandoned.
I would agree with that. And that's the other issue. There's the 200 and the negligence, the 241. And now I think that brings us to the contractual indemnity and insurance procurement claims. It's our position that just because we made these floor penetrations, which were integral to the work, they were necessary, they had to be there, that doesn't mean that plaintiff's accident arose out of Parkview's work. The plaintiff fell because of an unsecured wooden board that was covering the hole. He didn't fall because of the hole itself. That's the key here in terms of the contractual indemnity claim. And I like the case I mentioned earlier, Krzyzanowski makes it clear that if a condition, even a dangerous condition, is supposed to be there, it's integral to the work, then you can't hinge a contractual indemnity claim on that set of facts. Now, the adversaries point to a few cases where the injured person was an employee of the subcontractor that they were seeking contractual indemnity from. Now, certainly, if the plaintiff was an employee of Parkview, under the case law, his accident then arose out of our work. There'd be no denying it. But in this instance, he was not an employee of Parkview. He fell because of an unsecured plywood board over the hole. The fact that we made the hole, which was necessary and integral to the work, does not mean that it arose out of our work. And therefore, we believe that all claims against Parkview should have been dismissed by the court below and should be reversed.
Thank you. All right, we'll hear from respondent DiGirolamo? Mr. Singer?
Yes, thank you, Your Honor. First of all, as to 241-6, we didn't oppose it for the simple reason that we don't believe that the appellant is a proper labor law defendant, not a proper labor law section 241-6 defendant. So we didn't see any point in raising an argument on that point. We don't concede that there is no valid 241-6 claim against the remaining defendants, the owner and the general contractor in particular. And we also believe that section 23-1.5C3, which is the provision that we alleged, is applicable to the case. In any event, the other defendants have not appealed, so there's no question as to the viability of the 241-6 claim as to them that's properly before this court. I think at the end of the day, regarding the common law, and I'll call this a common law negligence case because that's what it really is, against Parkview. Parkview hasn't sustained its burden of proof. They haven't produced an affidavit from anyone who actually knew what was going on at that site. Their deposition witnesses were not aware of the relevant underlying facts. And clearly, to have an opening several inches deep, uncovered, is a dangerous condition. As far as we can tell, and as far as the Parkview's owner conceded, there was no reason why anyone other than Parkview would uncover that opening. And in fact, at the time of the accident, the work on that particular fixture, the tub depression, was not completed. The connection still had to be made. So we believe that for whatever reason, the likelihood is that Parkview went down and was working on it and left it uncovered.
Isn't that mere speculation? Because isn't that contrary to the testimony that's in the record, that they were there a week ago, that was covered less than a week ago? So isn't your argument 100% speculation that they were something responsible?
Well, I don't think it's speculation. I think it's circumstantial, and frankly, it's their burden of proof. So they have to show by some convincing kind of evidence that
What
that
about
they were
the
not there.
evidence in the record that exists, which is that that they weren't there for a week and then it was covered less than a week, within that week? Why isn't that enough?
We're not disputing that it was covered at one point, but we're also, it appears that they returned to the work, because if you look at the pictures, there are pictures, I think, at pages 887 and 888 of the record. The cover that was there was not the kind of cover that the carpenters would put in. That was specifically the kind of cover that hadn't been nailed down with these anchors on it. There was the kind of makeshift cover that the plumber, that Parkview itself was fabricating. So they seem to have taken a cover there, put it there, and then left it uncovered, as far as we can tell. And we have no reason to believe that anyone other than Parkview would have been responsible for that. As I pointed out in the McCullough case, there was also some records that indicated that no work was being done by the defendant. In that case, it was a carpentry contractor during the week prior to the accident. Nonetheless, the court said that there was a question of fact. In this case, we believe that it was Parkview's burden of proof, and they didn't sustain their burden of proof on that issue.
Thank you.
Thank you.
All right, we'll hear from 160 Madison, Mr. Guardaro.
Yes, good afternoon, Your Honors. Ed Guardaro for 160 Madison and MD Carlisle. Your Honor, I'd like to run through some of the issues here, because the question is, was there an issue of fact? That's the issue. So, in opposition to my adversary's points, I think there's a significant amount of proof in this record to demonstrate that there's issues of fact. Parkview's Mr. Lyons, the principal, testified that the holes were made for the fixtures. It's admitted. They're made for plumbing only. That Parkview was the only plumbing contractor on the site, and they would have the only basis, any reason whatsoever, to access those sites. Mr. Lyons and the supervisor, Mr. Aiello, the foreman, testified that basically what happened was, after they created the holes, they were locked down by another contractor, New York City Acoustical, with nail guns. So plywood was placed over them. And to answer perhaps Justice Schulman's question about, is it an inherent danger for, it may, I'm not going to concede the point, but it may not be originally, but once it's covered and uncovered, remember, it's a hole that is covered and no one debates that it was covered. Nobody, it was nailed down with plywood. Then it was uncovered. Somebody uncovered it. Now it becomes a dangerous condition because if there's not a covering on it, it's a danger to a work site. So I think we have to look at that issue. So that it's also admitted by the contractor Parkview that the hole was for a bathtub under 1577. Mr. Lyon says it, it's again, Mr. Aiello says it. And then both of them admit that they removed the covers, not this particular one, but they removed covers generally to access those holes to then put the piping up through from below. So these are all issues. Now, in this case, on page 1504, Mr. Aiello talks about those issues. And then the critical point, and the critical point is generally when Parkview opens the covers, what do? Well, critically, what's stated by Mr. Aiello and Mr. Lyons is that they don't re-nail the covers down. So again, now I'll get to Justice Kern's question in a moment if I can, but basically what happens is the testimony is that they generally would uncover the hole and then they would never re-nail it down. What they would do is they would put some type of other board on it, a cleat of some type, just to keep it sort of floating in the hole so it couldn't get easily kicked off. And what's really interesting, and I think plaintiff's counsel pointed this out on, if you look at page 887, the photograph shows that this piece of plywood has a cleat in it or two cleats in it, which would demonstrate that somebody uncovered it, put the cleats on it, and then recovered the hole. So the only person who has access to the hole, who controls the hole, who would need to cover the hole is Parkview. So to address Justice Kern's question of, isn't this all speculation? No, I would argue it is not, because all of these factors demonstrate, in the record, and I believe the trial court was correct, that there are clearly issues of fact here. Since the cover was not nailed down and it had this anchor attached to it per this photograph, and only Parkview would have reason to access it at all, and admit that when they access holes, generally, they don't re-nail them down, and they never proved what could happen otherwise. There's questions of fact just demonstrated by the photo alone. Now, the logs, the plaintiff's Parkview's argument about the logs only raised further issues of fact, because the court should also take cognizance of the fact that there was testimony from the site safety group, who's no longer engaged in the case, Mr. Manini. And Mr. Manini specifically said, we create this control area, and this is, generally unopposed. They control this. They control this control. They put this control area down so that nobody's in the way when the crab and the men and women are working on these curtain walls. However, people could come, again, perhaps speculative in the sense, but he said people could come behind the control area and do work at it. So it's not like they lock down, according to the testimony, they lock down the floor. So these are issues of fact. Is it speculation? Not when seen in light of the fact that there's no proof whatsoever that anybody else would have reason to or access this hole for any other purpose than plumbing, and then modify the actual plywood in a manner in which the testimony demonstrates it's unquestionably the manner in which Parkview would modify that cover. Now, the indemnity clause here.
I was going to say you're way over your time.
I apologize, Your Honor.
No, I don't need apologies. It's
Okay.
just we never have enough time for the cases that we have. It's just the way it is. So we do put a lot of store in your briefs, and I want you to be assured of that. But we need to let Mr. Summers speak. Go ahead.
Thank you, Your Honors. May it please the court, this is Christopher Summer on behalf of New York City Acoustics. I'm not going to spend my time re-arguing the points made by plaintiff and MD Carlisle because we raised those on our brief in opposition to the appeal from Parkview. But I would like to say that if the court does agree with Parkview and finds that the testimony from MD Carlisle and the site safety manager is persuasive, if the safety logs that demonstrate that the coverings on the 21st floor were covered and secured. If the court believes those arguments and grants Parkview's appeal, then we want the court to search the record and dismiss the claims against New York City Acoustics as well, because the evidence demonstrates that because that crab was being used on that floor for a couple days, no one else was on that floor, including New York City Acoustics. The photographic evidence demonstrates that that opening was covered, and that was done by New York City Acoustics. And without access to that floor and demonstrating that safety inspections were done and said that this hole was covered, then there's no possible way to find liability against New York City Acoustics. And as for the 241-6 claim, it was raised in detail in Parkview's appeal. The merits of that argument haven't been addressed. The fact that plaintiff chose not to address that is their mistake. And that claim should also be thrown out because there's no other supporting no supporting provision for the 241-6 claim if that provision from the industrial code is thrown out.
Thank you. All right, Mr. Cazares, your
yes.
Cazares, thank you.
With respect to the argument made by plaintiff that we didn't submit an affidavit contesting the negligence claims, I take issue with his characterization of our witnesses being not knowledgeable of what was going on at the site. One of the witnesses was the foreman that was there on a daily basis. The other one was the owner that walked the site at least twice a week. So the fact that we didn't submit an affidavit in opposition to the in the motions, I think just is not credible. We produced two witnesses who testified under oath that had knowledge of what was going on at the site. The other issue I want to address is by 160 Madison and MD Carlisle is, and I think Justice Kern hit the nail on the head, it's speculation. No one has come up, no one has even proffered a guess as to what reason Parkview would have had to uncover this floor penetration and work in the hole. Yes, the holes were made for plumbing, but once the hole was made and covered, and I think counsel for 160 Madison even admitted this just moments ago, the only reason for Parkview to ever do any further work in that hole is to run permanent pipes through the floors. Once those pipes go through the floor penetrations, there's no covering the hole back up. You can't cover a hole that has a pipe running through the floor to the ceiling. And certainly, if we want to look at the pictures that have been discussed here, there's no pipes running through those holes. We're talking about speculation. Also, with regard to what the witnesses from Parkview said about how they would recover a floor covering if they removed it. One of the witnesses, I believe was Mr. Aiello, said that it was a rarity that would ever have to be done. And the only time in the depositions where it was discussed as to how they would recover a hole was based on a hypothetical question, essentially saying, if you absolutely had to recover a hole for whatever reason, how would you do it? And he gave an explanation as to how he would do it. But the pictures are inconclusive as to who uncovered it or why it was uncovered. All we know is that Parkview made the floor penetration. It was covered by New York Acoustics. Parkview's work with respect to the hole was done until they were ready to run the pipes through. Parkview wasn't on the site for at least a week before the accident. In the interim, the hole was inspected, found to be covered and secured. And then on the date of the accident, for some reason, the cover is not on properly. Why it was, it doesn't matter. The fact of the matter is that Parkview had nothing to do with that uncovering on the date of the accident. And there's no evidence, no documentation, nor even speculation or a guess at a reason as to why Parkview would have uncovered that hole, if not to run pipes through the floor, in which case, if they did, you would see them in the pictures and you couldn't recover the hole after the pipes were run through. And for that reason, I think that Parkview was entitled to summary judgment. Thank you.
Thank you. Thank you all
Your
for
Honors.
waiting this afternoon and for your patience and for your argument. This session of the Appellate Division is now closed.
Thank
Thank
you,
you.
Your Honors.
Thank
Thank
you.
you, Your Honor.